I can have the panelists and the speakers with us right now. If you can put your video, Mark, Warda, Suryan, and also Reshma. Okay, we're just waiting for everyone video as well. If we can have a big round of applause, everyone, for the speakers from different parts of the world. Obviously, me and Warda are from Mauritius. We've got Mark from South Africa and Reshma from Saudi Arabia, but obviously based in Dubai. So I'm just going to quick introduction before we kickstart, really. So if I start with Mark, Mark, you know, quickly, what are we expecting from the mediator today?
What we can expect to try and see how we can best introduce mediation into our actual work environment. Mediation is not a well received process, and a lot of people don't understand how that works. So I hope to enlighten the people calling in about mediation and how it can benefit us in these times of COVID and these crazy times.
Fantastic, thank you, Mark. Again, can we have a round of applause for Mark, who has been here before talking on construction delay analysis last year. So thank you, Mark. Move on to Warda. Warda, great to see you, fellow colleague of from Mauritius, just like me, and the rest as well from Reshma and Suryan. So Warda, just quickly, what are we expecting in this challenging time?
Hello, hello, Anil. So today, what I will be talking about, I will simply go through the different forms of ADR that are common, and I will spend quite a lot of time on negotiations, and I will introduce to our viewers who what consideration do we lawyers take into account when we negotiate.
Fantastic. Yeah. Okay. Yeah. Thank you, Warda. Thank you very much indeed. I'm sure we'll hear you in a minute. Suryan, great to see you from the UK. Nice suit, nice tie. So what are we expecting from you today, Suryan? We can't hear you. You need to unmute yourself.
Hi, good afternoon. Thanks, Anil. Welcome, everyone. This afternoon, I'm going to talk to you about adjudications, adjudication proceedings, and how it works in the UK. Just to give you a brief overview and how it works and how it has been for the last 13 months, change the way that people are resolving their disputes nowadays. Yeah.
Thank you, Suryan. And I think we badly need you as well, because that's the last part missing, you and Warda. We've done Reshma, we've done Mark as well in terms of arbitration and mediation, but it's great to have you and Warda today just to complement the dispute resolution. Reshma, good to see you. You'll be the last speaker. I hope we have everybody will be here to listen to you as well. Reshma, quickly, arbitration. You talk about arbitration. Why is it so important?
Well, hi Anil, and hello everybody. I'm very happy to be here today. Well, I'll be talking about arbitration in the new normal, and I intend to cover three main things, not much detail, but generally the challenges caused by the pandemic, the appropriateness of arbitration, and also the new normal of arbitration.
Okay, fantastic. Again, thank you all the speakers. I'm going to do a quick introduction as I do, and then we'll get Warda back. Warda will do the presentation. We'll have a panel discussion. So can I ask everyone to put your little emoji, and a massive thank you for everybody and for the time. At the same time, I'll ask the speakers to switch off the video as I do a quick introduction and kickstart. So humble and honored to have all of you here. All right, so if I can ask Warda and Suryan to start the video. And as well as Reshma. Okay, I'm just going to make sure I've got my slide ready as well. And right, let me just make sure I've got the share view and just make sure. So just bear with us as here we go. So if you can see my screen, please. I'm just going to make sure. Okay, so quickly, just making sure I've got that sorted out as well. And okay. Good evening, everyone, and thank you for being here for the webinar CP talk on alternative dispute resolution, the new normal. And today we've got Warda, Mark, Suryan, and Reshma, which I will introduce as well formally. So thank you all for being here. I want to just show you quickly my next webinar, which will be next week. And it's a groundbreaking webinar on introducing Ecoform, which we'll do with acoustic for the built environment and the invisible power of sound, which is truly groundbreaking. So we'll be looking forward to see Lauren from South Africa, Jeremy from France, and Chris from Mauritius, who's the Director of Public. So it'd be great to see you as well for next week webinar. We'll give you more detail on that. So agenda today quickly, quick housekeeping as we do, introduction, what I will present, a panel discussion, Mark panel discussion, Suryan panel discussion, and then Reshma panel discussion. It's going to be really a very informative session today, and then Q&A and we'll conclude. I'm really, really humbled to see 530 of you registered, which is fantastic to see why you want to hear all the speakers today. So thank you to all the speakers and to all of you registered, all the participants today to register for this amazing talk. And of course, thank you to Mark, Warda, Suryan, and Reshma for giving back. Thanks a million. Quickly in terms of certificate attendance, hopefully it's going to be an hour plus, but please email me immediately if you can. Don't leave it too late at anil@cbdtalk.com, plus your feedback. Email me after the event so that I can issue you with a certificate attendance, but please don't email me after a week because then things changes quickly and I normally generate all the certificate for you. So if you can, after the webinar, please send me an email at anil@cbdtalk.com, plus your feedback, how you find the webinar in terms of the speakers, and any feedback will be most welcome. I think I've been there before, so I'm not going to touch on all of that, but love construction, love learning, love sharing, love people, passion about giving back, and almost 19 years in the construction industry now. As we do, we just want to do a quick menti.com. If you can have your name, country, and town, please. And the code is 6560 3070 6560 3070, and I'm just going to switch back to Menti. And that'd be good as well for the speaker and to really know which part of the country you are in Mauritius, and some of you are also watching us overseas. So I'm just going to go back to Menti.com and share the screen now. Let me just making sure we've got that perfect. And you will see your name coming up there. So if you can just use the code 6560 3070. So let me just make sure I've got that ready for you. And if you can have your name, please. So let's just see if that works. Menti.com 6560 3070. And we've got Mr. Jita as always. We've got Kimberly from Saudi Arabia. So fantastic to see you there. I'm now from India. I know we've got a lot of countries today watching us. We've got people from Sri Lanka as well. So great to see all of us really collaborating for this amazing talk. Fantastic. And as you can see, Mauritius being in blue because that's where we're all from as well. So we've got Bruno from Malaysia. I believe that's Dr. Bruno. Fantastic. Tanvir, Johan, Christine, Kamleshni. So again, great to see you all from watching us today. And that's the beauty of Menti.com as well. It's kind of really engaging to see. We've got Leo from Kuwait. So great stuff to see you all today. So some people have actually put the Menti code on it. It's no problem. It does happen. So we're just going to move on to the next question, which is fantastic. And the next question is, and it's going to make you think. So what do you understand by alternative dispute resolution? So some of you have said settlement, discipline, negotiation. You've got mixed up the countries, there's no problem. But please, if you can just put in what do you understand by alternative dispute resolution? Anything, someone has just said settlement, negotiation, and if you can just add that there, what do you understand by alternative dispute resolution? So I'm just going to give you 7 seconds to really go into it. Okay, as we can see, lots of the comments coming in now. And I think it's good for the speakers to see that in terms of negotiation being the big one. Wow. Settlement, negotiation, mediation. Settlement being the big one right now. That's why it's in blue and it's in the middle, followed by settlement and settlement again. So, all right. I think we've got a gist of what you guys want. So you talk about negotiation, settlement, and mutual agreement. All right, thank you much indeed for that. So we know the key word right now is settlement and negotiation. All right, thank you. And I'm just gonna stop and go back to my screen again. So just making sure I've got that switch. Right, thank you. Okay, so thank you for this. Can you see my screen again, please? If you can see my screen, if you can put your hands up, just to make sure we've got that validated. So many of the dispute resolutions, professional are from CIO, and it's the world leading qualification and professional body for dispute avoidance and dispute management. So I want to just show you a video as we do, a video just to show you about CIO. So let me just go back to the screen again and we'll share that with you. Just making we've got the sound and the screen and just do a share again. Okay, off we go. And if you can please, if you do hear the sound and the images, please just put your hands up. Off I go.
The best thing about being a member of CIR is being part of a community of ADR practitioners where one gains access to professional development opportunities through seminars, workshops, and accreditation courses, as well as access to networking opportunities through conferences and social events.
We offer a range of courses which equip people with the knowledge and skills that they need to to avoid, manage, and resolve a dispute, because we believe these are fundamentally important skills for people to learn.
The courses that I've taken through the Chartered Institute of Arbitrators have all been led by very senior practitioners. So also as a senior practitioner, it gives me an awful lot of opportunity to learn more, much more than sitting in a classroom and listening to someone speak.
Well, I'd recommend the CIR training because it's very thorough. It's recognised as a gold standard, and so having the qualifications will help you in your career.
First of all, one of the benefits of being an associate at Chartered Institute of Arbitrators is an opportunity to visit events and conferences on highly interesting topics. You are not only engaged in discussions, but also you receive plenty of networking opportunities.
Not only was I able to attend events with leading practitioners and scholars in the field of international arbitration, but also CR allowed me to meet other students from all over the world with similar interests and thus develop further networking and professional skills.
Okay, so thank you, and I'm just going to switch back to the slides and just make sure I've got my video as well as we conclude. So fantastic. Again, if you can see my slide, please, if you can put your hands up, it'd be great to see that as well. Thank you. Just to validate what I can see from my side. So, all right, thank you very much indeed. I just, when I was back in the university days, when I was doing my master's in June 2010, and that was a blog. The blog was called Alternative Medicine. And it talked really about how do I avoid court to court, and litigation can leave you with a headache, not to mention a large hole in your wallet, but dispute do not have to end in the court, says Paul Fox. And he talks about there's no doubt that litigating a dispute through the court is expensive and for most parties a last resort. This is well understood by the courts, and Lord Justice Jackson's recent review of civil litigation costs called for a package of reform to rein in the cost of civil justice. Pending such reform, the good news is that a variety of alternative dispute resolution procedures exist that offers alternative to court proceeding that can help preserve business relationship and save costs. The contract may contain dispute resolution provision that specify the alternative method that parties must try before they can be referred to litigation or arbitration. Either way, prior to embarking on litigation, the parties are obliged to consider using ADR and may face cost orders if they do not do so. So I found that very compelling as well. It was in June 2010 by Building Magazine. So I want to introduce you my next presenter and the speaker of today. That's Warda Peerally Sayed-Hossen. She's a barrister in Mauritius, and if I can ask Warda to put the camera on as well, and just to introduce Warda shortly. So can we have a big round of applause for Warda in the meantime? Warda has been a barrister practicing in Mauritius since September 2016. She read law at the London School of Economic and Political Science. She also an LLM in commercial and corporate law from Queen Mary University of London. She was called to the bar in England and Wales in 2015 at the Honourable Society of Brazil. She recently completed a postgraduate certificate in arbitration from Robert Gordon University. She has a wide range of experience in both civil contentious and non-contentious matters. In the past, she has prosecuted on behalf of the Office of the Director of Public Prosecutions in Mauritius. And finally, having a keen interest in alternative dispute resolution, Warda is also currently teaching the module at the Open University of Mauritius. So please join me in welcoming Warda. And I'm just going to switch off my screen. So Warda, thank you very much indeed. If you can share your screen, and then we'll get your presentation for around 15 minutes. So just make sure we got Warda's slide sorted out. So no pressure, Warda, of course.
Yes, I'm just, I will just be sharing my screen.
Yeah.
Yeah.
So yeah, share screen and then go to the PowerPoint.
Yes.
Of course, everyone, while Shorta is preparing for this, if you can obviously put your questions in the tab or your comment, your statement, we'll pick that up afterward, our presentation, and we'll have a panel discussion, of course. Are you okay, Shorta? Is it okay to you?
I am looking, I am just bear with me. I've lost my Zoom
tab.
Yeah.
Okay, let me just open your presentation on my side as well, just in case if there's anything that I can help later on.
Okay, so it's still not appearing. I'll try that again.
Yeah, so share screen and then get your slide. Fantastic. Yeah, it's coming up now. Thank you very much. Yeah. So it comes up and it just dropped. No, that was on my side actually.
No, it's not coming up on my side. So I'll try that again. I'll just close that and then still not coming up. So,
okay, so is the PowerPoint open?
I don't know what's the issue. It worked well earlier on.
Okay, is the PowerPoint open?
The PowerPoint is open, yes.
Okay, do you have the share screen in front of you?
One moment. Share screen is open.
Yeah.
PowerPoint. No, it's not coming up again.
Okay, do you want to switch off your PowerPoint and put it back on again? I've got the PowerPoint in front of me, but I'll let you open. If not, then I'll open it on my side.
Yeah. So I switch it off and then I start all over again.
Yeah.
Still not coming up, huh?
But when you click on share screen, does it give you? It's coming up now. We can see your entire screen. So yeah. So basically, it's working. So maybe open your PowerPoint again and try.
Open again.
And then if not, then I'll share the screen. No problem.
Yeah, I think you'll have to share it for me, Aniel. It's not working on my end. I don't know what's the issue.
Yeah, no problem. Can you see the screen, Warda?
Yes, I can see it now.
Okay, fantastic. So obviously we had a small problem, but it's fine. We'll sort it out. And just making sure Okay, just one sec. I'm just gonna need to just make sure I've got the right slide. Give me 1 minute, everyone. Okay, so right, can you see my screen now?
Yes, it's fine on my end, so I can see your screen. And
okay, so whenever you're moving on, just let me know and I'll push it to the next.
All right. Thank you, Anil. So for today, I will be talking about the constitutive elements of contract under both English and Mauritian laws. Why am I choosing contract? It is simply because contract law is central to ADR. And following the introduction of contract law, I will move on to the different forms of ADR that are common and what is the significance of contract law to ADR. Thirdly, I will look at, from a legal perspective, I will look at the factors that we lawyers tend to consider during negotiations. And I will briefly introduce the concept without prejudice to you, and we will discuss the mindset with which parties approach ADR. And to end my presentation, I will talk about the force majeure clause in the light of COVID-19. So Anil, if we can have the first slide, please.
Yeah.
Yes. So to start with, contracts with the first slide number 2, please.
Yeah, just one sec. I'll just there we go. Is that working now?
No, it's still on slide number 3.
Okay.
I need slide number.
Let me just make sure screen free. Now, just tell me what you can see now.
Contract law and ADR.
Okay. Now?
Relationship between contract law and ADR.
Is that what you want, yeah?
No, I want slide number 2. That's what are the constitutive elements of a contract?
That's the one.
Yeah.
Perfect.
No, there's one before it. That's the one with the table. Yes.
All right.
So and so to start with, in the construction industry, contracts tend to refer to agreements between the employer and the contractor for a project. Depending on jurisdiction, there may be different elements that would make a valid contract. For instance, if the law of a contract is the law of England and Wales, then in order to have a valid contract, you will have to have an offer made by the offeror, and this offer will have to be accepted by the other party. And this acceptance need to be a mirror image of the offer. Thirdly, you will need to have the intention of the parties to be legally bound. And fourthly, you will need to have consideration. Now, what is consideration? Consideration is a legal term to simply mean that there has been an exchange of value between the parties. It is some sort of bargain. So if I hire your services for constructing a building, then the sum I pay you will be the consideration for the construction of a building. Under the laws of Mauritius, however, the elements constituting a valid contract are different. So contract law in Mauritius is governed by the Code Civil Mauricien, which closely looks like the French code, and the constitutive elements of a contract under Mauritian laws. You firstly need to have the consent of the contracting parties, and secondly, you will need to have the capacity of the contracting parties. Thirdly, you will need a definite object of the underlying agreement. And fourthly, the obligation must have a lawful cause. What is cause? Cause here refers to its French, to the French expression la cause, and it simply means la raison d'être, of the obligation. It is the justification as to why the contract is being entered. Now I will move on to the third slide, and slide number 3.
Yeah, can you see it?
Yes, yes, I can see it. Thank you.
Okay, perfect.
So ADR, why ADR, and what is its relationship to contract law? First of all, what is ADR? I think earlier on the participants have given a right answer. It is a different avenue to resolve a dispute without having to go through the court systems. And we have a number of methods, a number of avenues that one can choose to resolve their dispute. Firstly, you will have negotiation. You can have mediation, arbitration, adjudication, expert determination, conciliation, and I'm sure there are other methods as well, but those are the main, the more popular ones. And I will now move on to the slide number 4. So now that you know what are the elements of a contract, and you know that your contracts has been breached and for which you are seeking redress. So this brings you to the question, where does contract law sit with ADR? Well, contract law is at the very heart of ADR, especially for negotiations, mediation, and arbitration, as they are rooted in the consent of the parties. So first of all, you need to agree. The first step is that you need to agree to use ADR. You can't impose ADR on another party. Of course, there are exceptions that have been made by legislations, and this will vary from jurisdiction to jurisdictions. But the general rule is that you need to agree to go to ADR. So when do you agree to go to ADR? Usually you will agree to go to ADR at the very outset of your relationship. So you will have to preempt down the line when you are signing your contract that there may be disputes. So that's the moment when you are agreeing to go through ADR. And this is achieved by inserting an ADR clause into your contract. I have reproduced an ADR clause from the New York City Bar Association, the ADR committee, on this slide, and I will invite you to look at it. You will see that the ADR clause makes mention of 3 different forms of ADR. It says that if a dispute cannot be settled through negotiations within 30 days, the parties agree to endeavor first to settle the dispute by mediation before resorting to arbitration. So there we already have 3 different methods of ADR that are being mentioned in that clause itself. And when you look at the way this clause is drafted, the parties cannot go to arbitration straight away. They first need to go to negotiation. If negotiation fails, then they go to mediation. And only then, if mediation has failed, can they go to arbitration. So we will say that negotiations and mediation are condition precedent to arbitration. Okay, so
okay.
This ADR clause is a standard example of what we call a multi-layered ADR clause. So you have different methods of ADR mentioned there, and negotiations very often is replaced by the term amicable settlements. So if you find amicable settlement in your ADR clause, then you know you will have to enter into negotiation first before resorting to another method of ADR. And how do you prove that you have achieved amicable settlement? This is usually evidenced by a trail of conversation, a trail of emails or letters that you will exchange between the parties. And here, I wanted also to stop there. Even if you have your negotiation has failed within, let's just say, those 30 days as stipulated by the ADR clause, and you have moved on to mediation, or even you have reached the arbitration stage, it is still open for you to continue negotiation. Okay. Very often you will find parties finding a settlement at the door of the court or of the arbitral tribunal. So negotiation can be an ongoing process. Anil, can we now move on to the next slide?
Before we move on to the next slide, I just want to give a quick poll. So it'd be good for a quick refresher as well. So I'm going to share the poll with everyone. We should have really started with that, but I think with the slides we were unable to coordinate properly. But I just want to know how many of you have been involved in alternative dispute resolution. So anything, if someone has been involved or not involved, how many of you have been involved in alternative dispute resolution? At least when we can get a bit more of an idea of who has been involved and who hasn't been involved as well. So we've got almost 60% of you have voted, and I'm so humbled to see all of you here today. 265 of you watching that now. We just got some few bits and pieces sorted out. Warda, you can have a drink of water as well, not a problem. You can have your water because I know you've got a few more slides, so it's fine. Right, so I'm just going to end voting now and share the result, and share the result with Warda now. So the one here is 40%, 39% involved, and 61% have not been involved. So that's the first one. So we know that 60% of audience not involved. And then I'm just going to play the Warda question now. And this is a good one from Warda. And the question from Warda for presentation number 1 is, how many of you have ever experienced a negotiation at the door of courtroom, right? What do you mean by that, Warda? As the participant of voting, what do you mean by that?
So basically what I mean is that you have a case ongoing in court. Your case has already been lodged. There are two instances. Firstly, one where your case has already been lodged, but your case is not yet in shape, and you are negotiating, in view of finding a settlement. And the second situation is where your case is in shape. It's going to be heard at 10:30 today, and at 10:25, your lawyer is talking to the lawyer of the other side in order to have a settlement.
Wow. Awesome. I've never heard that before, but we're learning something today already.
That's very common. I just wanted to tell you that's very common. We are encouraged to find a settlement in civil matters. So yes, the second case is very common.
And 60%, 63% have already voted. What do you think the percentage would be based on your experience right now?
I think it will be maybe 70% have experienced that.
Okay.
If they've been to court.
All right, fantastic.
They've experienced litigation.
Yeah, okay, so I'm just going to end polling now. 70% of the participants have voted, and I'm going to share the result. So a minimal 22% says yes, but a whopping 78% says no. So maybe while you're explaining it, so what's your thought on that?
I think probably the 78%, many of you have not been to court, have not been a party to a litigation, perhaps. That's why that's why perhaps that figure is inverted, because I am under the impression that most cases tend to be settled before it is heard, and that would include cases, commercial cases, and even family law cases where parties agree as to how they are going to live their divorce. Let's just say it's already agreed before going for a full-on hearing.
Okay, all right, fantastic. So we move on to your next slide on negotiation. Thank you everyone for participating. And I think it'd be good if you could raise your hand. How many of you have not been to court? Just raise your hand, we'll find out. If you can just raise your hand. Can you see that on the screen? How many hands are being raised, Warda?
No, I cannot see how many hands have been
Right,
raised.
so I've already got 50 on my side already.
Okay.
Participant has not been in court. So I think I can sense how the poll has been judged. So please take it away, negotiation. Thank you.
Yes, so I am now moving on to the 5th slide, and that slide is important because very often clients when they come to see lawyers, they don't know how lawyers negotiate. Well, there is a standard for negotiation, and in order to effectively negotiate, one needs to have an assessment of BATNA and WATNA. So what is BATNA? BATNA refers to your best alternative to a negotiated agreement or settlement, and WATNA is your worst alternative to a negotiated agreement or settlement. And usually when you're going to calculate your BATNA, it's a figure. So, these terms, BATNA and WATNA, are very important, especially when you're going, when what you're seeking is a monetary remedy, a pecuniary remedy. Then you will need to have these two figures. And it's one of a few times when lawyers actually use maths. So yes, so BATNA is basically, it is an attempt to calculate the figure that you're most likely to be awarded if the case is to go to trial before a court or an arbitral tribunal. And in order to calculate your BATNA, sorry, before I move on to the calculation of BATNA, WATNA, on the other hand, it refers to your worst alternative to a negotiated agreement. And in effect, it is the estimated lowest figure that one could get if they were to go to court or before an arbitral tribunal. And the general rule of thumb is that you never settle below your WATNA. Okay, so we have these figures, and these figures will be discussed with clients before we enter negotiations. And if I can move on to the next slide, where I will look at the factors that we tend to look at when calculating a BATNA. So that will depend on the sums that you are claiming, any interest due on those sums, the chances of your success at trial. So that's the risk you're taking of not winning at trial, and any valid deductions that need to be made from the claim. For example, if your case require an expert to come and depone, for example, expert witnesses, these can be costly. And also you'll have to take into consideration any costs that may be irrecoverable from litigation. All right. And on to the seventh slide, please, Anil. Now that you and your lawyers, you have calculated your BATNA and your WATNA, so how do you proceed next if you're negotiating? Then the next step for you is to make an offer, or you will wait for the other party to make an offer. So how do you make an offer? Offers are normally communicated between lawyers, or they are exchanged by formal letters. And these exchange of conversation or exchange of letters, exchange of correspondence can be through email as well, or done on, or said to be done on a without prejudice basis. So what this means, it means that this exchange of offers takes place in private, and none of these offers made by the parties are going to be enforceable against them if the offer is not accepted. Okay, so let's just say you are at negotiation stage, there has been an exchange of offers, but none of it have been accepted, and then now you move on to mediation or you move on to arbitration. These offers will not be taken into consideration. It is as though you start your next method of dispute resolution on a clean slate. All right, so there is a second term that you should know, and that's called without prejudice save as to cost. It simply means the same thing as without prejudice, but when it comes to the time when the court will look at who will have to bear the cost of a day, then the court will look at the conduct of parties when ADR was being attempted. Okay, so for example, if a party has unreasonably refused ADR, then you can expect that this party can bear some consequences. All right. So if your negotiations result in a successful settlement, then contract law again will come into play, and then you will have to draft your settlement agreement, okay? And this settlement agreement can be enforceable before a court of law should one of the parties default. This is just for the sake of completeness. If I can move on, Anil.
Yeah. We've just gone into
Now that
mindset.
you know, yes, now that you know about how we lawyers tend to negotiate, this begets the question: with what mindset should one approach ADR? Do we or should one approach ADR? Well, do you need to have the same mindset that when you go to court? If you go to court with an adversarial mind, will you approach ADR with the same type of advocacy? I think no. You will be slightly more, let's just say, softer, because ADR is not only consensual in nature, but it is also pro-settlement. So your mindset will be less adversarial, and you will have a presumption. There is a presumption of a willingness to keep your commercial relationships. So why is that? It's very often a dispute can arise between parties on one contract, but at the same time, they have a number of other contracts that they are honoring. So you will want to keep your commercial relationships, and so you will approach ADR with a pro-settlement mindset. And coming onto the remedies that you can have in ADR, it is possible with ADR to have more creative remedies. And when you go to court, the judge will be limited to the remedy that you have asked for, or for the remedy that the law allows the judge to give. While when you go to ADR, you can have more creative remedies. And this is very relevant today, because since the beginning of COVID-19, we've also had a number of cases in our courts that are still waiting to be heard because they have been postponed due to lockdown. And when you are going to ADR, you will not have the backlog of cases that courts have. So it can be faster, and yes, and that's one obstacle that is being curtailed. All right, and this is very interesting for the construction industry, where time is of the essence. And before completing for today, one of the hot debate occurring at the moment in ADR is the enforcement and the interpretation of the force majeure clause. What is force majeure, and why is it important? So many contractors are coming to lawyers and asking whether they will have to whether liquidated damages will have to be incurred arising from delays due to government restrictions that have been imposed owing to COVID-19, and some of them want to rely on the force majeure clause. The force majeure clause provides that for delays or failure resulting from events, circumstances, or causes beyond the control of reasonable parties to be excused. But then the question is whether these events that we are living, do they amount to force majeure? That's a question that many contractors are asking themselves, and we do not have a clear answer yet. Onto the 10th slide. In order to be able to answer answer this question. So you will have to look at the contract. If ever force majeure has been defined, sometimes some contracts would list a number of events that they will consider to be force majeure, but sometimes these events are not listed. And you can also look at legislation. It can be defined, or you can have some guidance from legislation, or you can look at case law. In Mauritius, we'll be looking at both legislation and case law. And onto the 11th slide. And at the moment in Mauritius, we do not have a clear answer, except that a force majeure event has been defined as one that has the following three constituent elements: extérieur ou étranger à la chose, imprévisible, and irrésistible. Alors, so extérieur ou étranger à la chose means something that is alien to the obligation, that has not been. Imprévisible is one that you could not have forecasted, and irrésistible is simply an event that you cannot avoid. So at the moment, there is no clear answer. It will depend on a case-to-case basis. The approach of the court in the past has been to look at the relationship of cause and effect between the event and the breach or the non-performance of an obligation. That will be for me completing for today, and I am open to questions.
Okay, thank you very much indeed, Warda. Thank you. I know we had a small issue with the slides. I've got your message, everyone. Big round of applause for Warda on that. And if I can ask Surya, Reshma, and Mark to come back to us on the panel discussion quickly. We've got a few questions already on. So if I can have Reshma as well as Mark and Shuren. I can see lots of messages on the WhatsApp with Shuren trying to open his PowerPoint. So we've got some questions, just making sure I've got that. And Shuren, are you here? Don't know if Shuren is here, but we will get back to him shortly. Right, so Mark, just quick one. What's your thought on the presentation on Warda in terms of relationship between contract, law, and ADR? You having been in the industry for so long, what's your views on that? The relationship between contract versus ADR?
ADR would be a subset of contract law, and the two, I believe, the two goes hand in hand. If you're going to go on a pure litigation route, you're going to end up having to pay huge amounts of costs. The alternative dispute resolution method provides a option in order to keep relationship. As Warda said, you will find that a number of times certain employers like to appoint a number of EPC contractors or certain EPC contractors. That doesn't mean that they don't have disputes. But if they're going to take that to court all the time, what's going to happen? You're going to find that this contractor is not going to want to work with the employer. So the ADR provides a mechanism within the contract law to resolve those disputes without creating huge fights, without incurring huge costs, and to provide a quick solution or a quicker solution. Although nowadays ADR takes just as long as litigation, it can become just as costly. But you've got to utilize the contract law aspects of your contract correctly and to gain the benefits of ADR.
Okay, thank you, Mark. Reshma, just quickly what I talked about in terms of relationship between contract. You are now an arbitrator, but how do you see the relationship between contract law versus ADR?
Well, my view is that, well, I think Warda explained it very well. ADR, I mean, the various forms of ADR are usually consensual, so parties have to agree to them in their contracts in order for them to apply. There are some exceptions. So for example, there's statutory adjudication in the UK and in other countries in the world. In some jurisdictions, there's also statutory mediation, there's mandatory mediation.
Yeah.
I think we may be going towards that route now because mediation is proving to be very effective in many jurisdictions, and then, you know, it wouldn't be long before others follow. So I think ADR is taking an increasingly important role generally. And it's great because it's helping the courts deal with disputes. The courts are overburdened by all the disputes that they have to handle.
Okay, thank you. Moving on to Syrian. I know you're having some issues with the camera as well as the PowerPoint. It's not a problem. We'll sort that out shortly. Just quickly, Syrian, we talk about you being an adjudicator. How do you see that relationship between contract law and adjudication?
I mean, I will explain later in my presentation. Adjudication itself is a product of contract. So whether you're doing statutory adjudication here in England and Wales, or if you're going to do it in another jurisdiction where you do not have such a statute or legislation, you should have it in your contract. Without it in your contract, whether expressly or impliedly, you cannot go to adjudication. Yeah.
Okay, thank you. We'll just pick up some question as well that come back in the screen. Mark, there's a question from Kuldeep Singh, which is quite a good from India. And what Kuldeep says is, how do we declare any matter as dispute?
Normally, you would refer to your contract. Your contract will set out the procedural and substantive conditions on how you would declare a dispute, and it normally sits under your dispute resolution clauses on your contract. You've got to follow your contract to the T.
All right, fantastic.
Anil, can you repeat that question for me? Is the question is what do we consider to be a dispute?
Yes. Or how do we trigger a dispute?
I mean, a dispute in terms of, I mean, if you look at arbitration or even adjudication, the way it works in adjudication, before you start or issue a notice, a dispute must have been crystallized. And how do you know a dispute has been crystallized? There must be, for example, in the construction sense, a claim has been made, and there is either impliedly by email or any side of, sort of communication, or expressly that claim has been rejected.
Yeah.
So if you, as a contractor, have made an application for payment, for example, if the employer or the QS says, okay, replies and say, I would like to have substantiation or further information, it means that there's no dispute has been crystallized. It has to be affirmed there that that claim has been rejected. Like I say, if there's no response, then we will look at a reasonable period of time. You can't say, within 24 hours, you haven't had any response, so there's a dispute there. You will normally go to the contract. Yeah.
All right, thank you. Warda, I've got a question. We've got about a few more minutes before we move to the next speaker. We've got a question from Mr. Jay Soridu. He's one of the leading architects in Mauritius. And he's asking you, can a verbal agreement constitute a contract? We can't hear you. You're on mute. You're on mute.
Yes, sorry. It really depends. So, for example, in Mauritius, we have a restriction in our Code Civil Mauritian that states that anything that require a payment of more than 5,000 rupees needs to be in written form. So that's a restriction put in the laws of Mauritius. Now, if you don't have a formal contract, your trail of letters or email can constitute what we call a commencement de preuve par écrit. So that's it simply means a start of evidence in writing of that contract.
Okay.
So you will, yeah.
All right. Thank you.
That's how it is in Mauritius at the moment.
There's a question from Dirajan. I think I'll go through the table here, and he's saying he talked about thank you, Warda, for your presentation. I understand that ADR can provide a quicker way to resolve contract issues in the construction sector, or as a matter of fact, in any other sector. However, do we have an idea of the cost involved? Obviously, we're not going to go in that one, but he says about lawyers can generally be very expensive. On a separate note, does the relevant arbitrator, which is much more meaningful question on this one, which you have, on a separate note, does the relevant arbitrator, mediator, adjudicator need to have a legal background? So if I start with Reshma, do you have to have a legal background to become an arbitrator?
You don't have to, I mean, it's not a requirement for one to have a legal background in order to be an arbitrator, but it is recommended. So, you know, I've said that before, probably not into this presentation, but there are arbitrators who are construction professionals, financial professionals, technology experts, and we need arbitrators from different backgrounds because they bring different things to the table, and they make arbitration more effective. And the way that I see professionals tend to go about it is they are, let's say, we have an engineer. What they tend to do is, you know, maybe do a master's in law or take some law courses so that they are able to manage the process well. Because in arbitration, the technical skill is important, but there's a need for a little bit of legal, I mean, not a little bit, there's a need for the legal knowledge and being able to apply the law as well.
Thanks, Reshma. Because I will move on quickly with Mark, Surin, and Warda before we move to the next presentation. Mark, I saw you strongly nodding your head. Does that mean we don't need legal background?
The pundits say you don't need a legal background. I tend to disagree. I believe you need to have a legal background because arbitrations have become a legal minefield, especially a single person sitting as arbitrator. If you have a panel, you can draw in a technical actual background, but as arbitrator, you deal with a lot of legal concepts. Now, there's a trick also there because if you are a delay expert like I am, and I'm considered as an arbitrator, I cannot use knowledge as a delay expert in sitting as an arbitrator. So there's a very fine line you got to consider. But I believe you need to have a legal background to sit as an arbitrator.
Awesome, thank you very much indeed. So moving on to Syrian before I conclude with Warda. Syrian, do we need a legal background to become an adjudicator?
Yes, I think most of the adjudicators panels, for example, here in the UK, whether you come from the actual legal practice or as a technical individual, whether you're an engineer, architect, or quantity surveyor or project manager, they will ask you to have a legal background because, like I say, adjudication is a matter of contract. So you need to have experience and knowledge of how you interpret contract provisions to be able to deliver a correct decision. And hence, yes, I will say it's a must. And most of these panels will be asking you to display your knowledge, experience, and qualification in contract, for example.
Absolutely, absolutely. Thank you. We'll move to Warda to conclude on that. You're on mute, Warda. So if you can unmute yourself. Warda, just quick one. Do you need to have a legal background based on your experience of litigation in Mauritius? Do you have to have a legal background to really exercise?
To exercise in the courts of Mauritius or in ADR? In
ADR, in the court, both sides of it. Do you really need a legal background?
In the courts, you will definitely need a legal background. You will need to be called to the bar in order to be able to do advocacy before the courtroom, before the bench. That's a requirement of the law. In ADR, I think yes and no. I think no in the sense that you can have an accountant, you can have an engineer being an arbitrator, helping in an arbitration, for example, or aiding negotiations. They can help, but if they do not have that, let's just say, legal knowledge of legal sphere in which they're operating, it will be a bit complicated for them to understand disputes and how they are resolved.
Okay, and finally, just quick one before we go. You know, you said when we had the poll question up, the poll comes up and you said you can actually negotiate before you do the final judgment. Could you just explain that quickly for all of us watching? Because I never heard it, and probably will have the views of the panel.
I did not say before the final judgment of a court. I just said that we can negotiate on the day that your case is going to be heard.
All right.
So if today your case is in shape, all your witnesses are present in court, but you still have not started your case, it is still open for the parties to negotiate. It's all right to ask for the bench, okay, please give me 5 minutes. I think we may find a settlement.
Okay.
It is something that's possible.
And okay, thank you. Suryan, have you come across what Warda has said?
Could you repeat the question? What
have you come across what Warda has said, that you can negotiate before the hearing?
That's mostly what happens, especially in Mauritius. My own experience is you could have hundreds of court cases, civil cases, but most cases will be settled like 5 minutes before the hearing. Unlike the UK here or in England and Wales, you are encouraged to go into mediation, which they've done in Mauritius now, but most of the time that would be dealt with without prejudice meeting. But my experience is, yes, in Mauritius, 5 minutes before the hearing, sometime once you appear before the judge, before the trial, that it's the judge who is going to ask you, look, I'm going to give you half an hour or an hour, go and speak to each other and come back and let me know whether you've managed to resolve this or not.
All right, wow. And Mark, in South Africa, do they have similar negotiation technique?
Yes, I've been involved in it now where it was set for arbitration. In the contract, there was no provision for mediation. However, the parties agreed to mediate. They went to the mediation and were successful. So it's all about the parties, agreeing to the parties. The parties can agree on what they want to agree upon.
Wow, okay. And Reshma, in your experience in UAE, have you come across that, or people just wait for it?
Strangely enough, if a case comes, I haven't had an experience where an arbitration matter has been resolved, because parties tend to try really hard to resolve it through other means, and it's only if they cannot resolve it through those means that they go to arbitration, and then they become very decisive and confrontational, and tend to go all in.
All right. Okay. So sounds like a Bollywood movie. Sounds like a Bollywood movie. 5 minutes before the actors turn up, and there's a nice song, and then it's all hunky dory. Fantastic. Thank you very much indeed. Let's move on to Mark. Mark, so take it away with your presentation, and then we'll come back. Please, all the participants, can you send your question based on Mark's presentation? And then we'll take all your general question at the end. So obviously, Warda was a bit more generalized. So if I can ask Reshma and Warda and Sweden to switch off their video. Mark, take it away. Thank you very much indeed. Can we have a big round of applause for all the speakers, please, as we get into this knowledgeable session? Mark, take it away. And thank you from South Africa.
Thank you very much, Anil. It's good to be back. So I'm going to follow on from what Warda said. There are a couple of elements that contribute to disputes. The first element is that inevitably the parties have got different positions. Now, if party A as BATNA is different from parties B, they are never going to reach common ground, because normally you'll find that the BATNA is brought down from the top, and they will say, we will not, or the BATNA and the BOTNA is brought up from executive, and they will say, we would not go below this threshold or above that threshold. So the parties' position in terms of their BATNA and BOTNA will contribute, or is an element that contributes to disputes arising, especially under construction contract, which I am involved in. Now, there are specific parties' interests is again driven, because as Warda said, your BATNA and your WATNA considers a number of factors and a number of calculations. So, and you'll find it is driven primarily by a commercial interest. And again, if those two parties' positions differ and the interests are differ, then you would end up, or will contribute to a dispute. The final element will be the parties' needs. And what is the underlying issue causing dispute? Now, this is where mediation plays a huge role. It's trying to understand or establish what is an underlying issue causing the dispute, understanding what the parties' positions are, what their interests are, and what's keeping them at that specific position, or what's making them stick to that specific interest. So normally in the contract in South Africa, we don't use, we normally tend to use good faith negotiations through senior management structures. Then we'll go into a fast track dispute resolution, which is adversarial in nature. Now the weaknesses of these two provisions is that they are focused on victory and not on progress. And also it is always conflict driven, because again, if your specific parties, the BATNA and the WATNA, the gaps cannot be closed. It's about, I want to win, and for me to win, there must be a loser. And that brings me to a Latin legal phrase. I'm not going to try to explain it, but translate to English as, let justice be done, though the heavens fall. So it says, let justice be done, though the heavens fall. And this maxim signifies that justice must be realized regardless of the consequences. That is your typical dispute process, is that you're fighting for justice. A party is fighting for what he or she perceives to be his or her justice, regardless of the consequences. Regardless if they're going to break down the relationship, regardless if they're going to spend 30 million rand on a 5 million rand claim. So, whereas mediation moves you away from that maxim. We've got to consider the consequences, and justice should not be done at all costs. Dorothy Thompson, she was a journalist, and what I like the maxim, she says, peace is not the absence of conflict, but the presence of creative alternatives to it. Alternatives to passive or aggressive responses, alternatives to violence. I've seen or been involved in some arbitrations. It's like a war zone. It's not violent, but it's very close to being violent, where you in order to win, you got to break down the opposing parties' position. You got to take his expert to pieces. You're attacking a person, and what we'll find is that normally what precedes that is these aggressive emails. You type in capital letters. You want to get your point across. You want that 5 million rand, or that 50 million rand, or 200 million rand, or you want that 50 days extension of time. And what you find is when the parties are very close to the project, they tend to be aggressive at each other. The relationship is broken down, and even if you introduce good faith negotiations by the management team, that relationship is so broken down that there's always going to be conflict. It's a conflict involved in. And whereas mediation provides a creative alternative to this environment, or dispute-driven environment. So, what is mediation? There are two different types of mediation I've been involved in. The one is evaluative mediation, and under this process, the mediator is appointed by the parties. He reviews the positions of each party, and then he points out the weakness of that party's case, and he will tell, this matter goes to adjudication, or arbitration, or litigation. This is your weakness, Mr. Contractor. This is where you're going to fail. Or Mr. Employer, this is your weakness. This is where you're going to fail. So he tries to get the parties to a solution by advising them, or by looking at their cases and matters, and providing or predicting how an adjudicator, arbitrator, or judge would assess it. And hopefully common sense would prevail, and you can get the parties to the solution. More often than not, I've found that unless both parties are trying to resolve this matter, and they want the evaluative mediation, it will fail. Because party A would want to have a mediator appointed, evaluative mediator appointed, that will be that will try and side with him, and party B will looking for the same thing. So in the first instance, you would be arguing about the mediator, so it falls flat already. Whereas facilitated mediation, the party is the mediator, but the mediator encourages each party, discuss with each party, look at the reason underlying position, and encourages the party to come to a solution. The mediator does not preside on an award. He cannot dictate to the parties how they must go about it, but he encourages them through a process that is being taught in qualifying as a mediator. So, what are the elements of the mediation process? As Warda said, it's a voluntary process. Both parties must agree to mediation. If the parties don't agree to mediation, or both parties don't agree to mediation, you cannot go to mediation. Mediation is a private matter on two fronts. In the first instance, what is discussed between a party to mediation and the mediator is private and confidential. And that mediator can only divulge what is being told him by party A to party B if party A gives that mediator the authority or allows mediator to disclose to party B what was just being disclosed to the mediator. And that makes mediation a very tricky process. So, for example, I can tell, say, Anil, the mediator, Anil, I'm prepared to pay Warda 30 million rand, but you cannot tell her that. You cannot tell I'm prepared to pay 30 million rand. So, and in his papers, he said, oh, we pay 10 million rand. So now you've got to go to party B and you're going to try and get party B to come to a solution without telling party B, listen, there can be a potential 30 million on the table. So that's the first aspect of private, the nature of mediation being private. The second nature of mediation being private is that whatever is discussed within the mediation cannot be disclosed to any third party to the mediation. So it cannot be taken to arbitration, litigation. It cannot be taken to the media. So what gets discussed there is private. And what we find as a good selling point, we always tell a party, if this matter goes to arbitration or to litigation for that fact, when it goes to litigation, it's no longer private. Now all the dirty laundry gets laid out for the whole world to see. And there could be reputational damage in terms of the brand, etc. So those are the things that you got to consider. And that is how we also try and convince people or parties to follow the mediation actual route. Then the mediator must be a neutral person. Now, in the construction environment, it's very difficult to appoint a mediator that hasn't come across either of the parties at some point in time during the construction process. So as a mediator, you need to cut you got to be a neutral person. You got to look at the matter in a neutral manner, and you've got to deal with both parties in a neutral manner without having the perception. And the word perception is important because you may inadvertently not see yourself as being siding with the party, but your actions, your body language, the way you speak, and the way you bring across various elements can be construed or be perceived as being biased to one or other party. So as a mediator, you've got to be very careful that you are always perceived and act in a neutral manner. Now, another element is that mediation is a negotiated settlement. So like in adjudication or arbitration, an award is made, whereas the mediator cannot make an award. He's got to negotiate a settlement between the parties. And the parties is their settlement. And what we'll find is that at the mediation, sometimes it's led by the lawyers, but I strongly would advise you against that, because as you heard, the lawyers have got BATNA, WATNA, whereas if the parties lead their own mediation, they've got their own interests at heart. What I always recommend is you have your legal representative there. Take the advice from him. Let him be there when you got to finalize the agreement. But I would strongly recommend that you don't let the legal part, your legal representative lead negotiations, because you will have your best interests at heart. And then mediation is non-binding to the point of agreement. What it means is we can agree to mediation party A and party B. However, at any point in time of that process, either party can say, Mr. Mediator, sorry, stop. We're gonna stop now. We're gonna walk away. However, if an agreement is reached, then that agreement becomes binding. And if you don't stick to the agreement, it can be deemed to be a breach of the agreement, and it can be taken to court, and you can seek your remedy to the courts. And the last aspect is the authority. It's hopeless sending someone to a mediation, representing your interest, but it's got no authority to act or to make or to settle. So, for example, don't send a quantity surveyor to a mediation if he cannot, he or she doesn't have authority to negotiate a settlement. So let's for argument's sake say your claim is for 30 million rand, and you try to negotiate and you get it down to 20 million rand. If that person representing you at the mediation is not authorized to bring it down to 20 million rand or to make it an offer, then the mediation is not going to work. So the parties to the mediation must ensure that the person leading the mediation on their behalf has the authority to act. What normally happens is you would normally have the person has been involved in the construction process and understand the process, leading it, but you have a decision maker in the background. And when the mediator asks you, do you have the authority? You will say, no, I don't have the authority. However, Mr. X or Mrs. Y is here, and this person has got the authority to negotiate a settlement. And that's important. Then the mediation process, taking the mediation process. So what will happen is the mediator normally will get both parties into the chamber, mediation chamber, and the mediator will make an opening statement. And the opening statement will go along the lines is that parties, we thank you for choosing this process. Please be advised that it's without prejudice, it's a private matter. You can stop at any point in time. However, I would want you, or I would appreciate if you can try and see the process through. Normally, you will book 1 day for mediation to try and resolve it. However, the parties can extend it. When I say 1 day, that 1 day can go to midnight. So a mediation can run for 23 hours a day or even 24 hours for the day. And it is a very tiring process. So the mediator tries to appease the parties. Now the opening statement on the various parties. Now this is where the mediator needs to try and calm things down, because with your opening statement, you try and, as a party, with your claim, the respondent, as a claim, you try and bring everything out. You try and paint the respondent in a bad light. But the mediator is going to calm it down and say, parties, this is not, you don't attack people privately, just look at the facts. Now, and the same with the respondent, you will make his opening statement, and again, you will find that it tends to be a huge, it's like venting. So you're getting people to vent, but as a mediator, you've got to calm the process down. What then happens is that the mediator will then caucus. So the respondent, the claimant and his team will go into one chamber, secondary chamber, and the respondent team will go to another chamber. Now the mediator will then go to the claimant's chamber, and we'll talk about it. Now, what you must remember that your claim document, your expert report, your legal opinion does not matter in mediation. Because I'm not going to look at a delay to say you would delay by 20 days. I want to try, as a mediator, negotiate the actual settlement. So those things, I've got to review it, but my focus should not be on talking to how to it's talking to what is your position, how can I change your position, and why are you at the position now. Then you will go to the respondent, and you'll also the claimant, can I take what you've told me to the respondent? And if you have a difficult claimant, you'll say, no, you can't. Then the mediator goes to the respondent's chamber and follows the same process and tries to get to the crux of the matter. And again, and this will carry on back and forth between the various chambers until they can come to some sort of agreement or the mediation ends in its entirety. Now, as so during those probe and explore sessions, you got to look at the facts, you got to probe the facts, you got to probe positions and explore the options, and not say, okay, Mr. Claimant, you're right, you need to tell the 30 days. You got to explore. So, Mr. Claimant, is it really 30 days, or is it 10 days, or is it no days? And those are the type of things you got to explore. Integrated negotiating. Now, Warda has spoken about negotiating. Now, this is a different form of negotiation. Don't sort of do Batnam or whatnot. you look at how can I integrate the negotiation between the two parties and to try and get them to move from their positions to a position that is neutral, but that can create a settlement between both the actual parties. So the mediator's role is restricted to convey information offers between the parties, to explore options and concessions, and then also to test the reality of the positions, to test, is this a valid argument? What are the alternatives? And then also, most importantly, is to move the process forward, because what you would find, or I've experienced a number of times, is that the parties sometimes tend to have a specific strategy to try and derail the mediation, to state that, look, arbitrator or Mr. Adjudicator, we've tried mediation, it hasn't worked. There's a date, went on that date, no one can dispute it, and it hasn't worked. We did not come to an agreement. And that is just the process that they go to the actual motions. But as a mediator, you need to understand those roadblocks and challenges, and you need to find ways and alternative ways, and ways that is not bound by a specific contract, to move that process forward. You've got to keep the parties engaged. You've got to keep the parties trying to negotiate the settlement, and that is not always easy if you have one or both parties that is only through the mediation, because the contract says you must go to mediation before you can go to any other dispute resolution mechanism. So in the pandemic, now there are benefits and there are disadvantages as well. So from a benefits point of view, the cost savings. Normally you would have to fly a mediator out to a neutral venue, especially if you are working with international contractors. The contractor is in South Africa, but the contractor, international contractor is sitting in Spain, and the person authorized to attend the mediation is sitting in Spain. Then the benefits are that you don't have to fly people out. There's a benefit on the cost cutting on accommodation, and also the ease of negotiating. What you will find is some people find it easier to speak to a camera or to a screen than it is to face, I won't call it opponent, but to face the opposing party. And whereas you will find that when the two parties get together, they might want to throttle each other or kill each other, but when there's a screen between the two, it makes it easier to calm everybody down and to try and move the process forward. There's also a downside, and the downside is that with the advent of Zoom and Teams, with the mediation being a private affair, you could inadvertently keep the opposing party into a caucus session, and the opposing party can hear and listen to what's being discussed. So those are the issues that, I mean, we all struggle with information technology at some point in time, and those are the disadvantages. Other than that disadvantage, some people, as some people say, it's a benefit to talk to a screen. Some mediators refuse to, or they would turn down the appointment to have a mediation online. But it all depends on what the personal preference is, and also the parties. Some parties say, no, we would want a face-to-face mediation. Even in this current pandemic, we've had instances where mediations, parties said, we want a face-to-face mediation. We don't want to through Zooms or through Teams. So those are the pros and cons of it. Matters that are not suited for mediation. When it's a pure question of law, precedent means is that you're trying to discuss what has been, what a court or it's found on another matter, and you're trying to create precedents in terms of that. When it's a question of law, pure question of law precedent, that type of matter is not suited for mediation, because you have got to give an answer. You've got to make a position. Mediation is not giving a position or giving an answer, but giving the parties to work together. And a number of times you'll find that I've been involved in instances where the parties are saying, you know, we're not interested in any ongoing relationships. So we're not interested in mediation. We go to the motions because it's required in the contract. But at the end of the day, I'm going to go to arbitration because, or litigation, or if there's no provision for arbitration, to arbitration because the award is final. I believe that I don't want to talk to you again, I don't want to work with you again, and I'm going to go for you at all costs. Let justice prevail, though the heavens may fall. Yeah? And there's also outside pressure to adjudicate, arbitrate, and litigate. So you might find that what we find a lot in South Africa, a lot of the international courts are coming in, and their head officers are saying, guys, it's a waste of time mediation. Follow the process, but we want you to either adjudicate, arbitrate, or litigate. Get it to that point for us, and you will find that that normally flows from the situation where no ongoing relationship is contemplated.
Okay. All right, Mark. Thank you for watching lead, Mark. If you can stop sharing, please. And then we'll just quickly take a panel because we've got 2 more speakers. It's really, really captivating. If I can ask Reshma, Warda, and Suren to put their videos back on. Quickly, we'll take few questions on mediation. Starting with Warda, Reshma, waiting for the, and if you can unmute yourself as well, please. Quickly, in terms of mediation, Warda, what's your best advice? Anybody going, I mean, we've got 250 plus round participants right now. What's your advice, anybody going into mediation at the back of what Mark has said?
Well, if you're going for mediation, you have to know that you will have to make an effort, because the mediator will not be the decision maker. At the end of the day, you will be the decision maker. So at the back of your mind, you will have to be pro-settlement.
Okay. And based on your experience in Mauritius, do we do lots of mediation?
I know the family court does it. Sometimes some cases are referred by the Supreme Court for mediation, and that will usually be cases where family members are involved. It doesn't need to be family related cases. It could be property cases, and sometimes planning matters as well are sent for mediation.
All right, thank you, Warda. I'll move on to Reshma quickly. Reshma, your advice on mediation at the back of what Mark had just said. What's your experience in the UAE?
Yeah. Thank you, Anil, and thank you, Mark, for such a great presentation. I am very pro all the dispute prevention and avoidance strategies, and I think that, you know, where parties feel that there is a chance to resolve their dispute, they should really attempt to resolve it out of arbitration or out of court, because, you know, it helps them save costs, time, and complexity, because you know it's less complex to go for other types of ADR. In terms of practically in the UAE, there, like I said before, there's an increase. I mean, people are increasingly adopting mediation, but I don't think we're in a place yet where you know it's being widely adopted. There is mandatory mediation for employment matters here, and generally I think that works well.
Okay, thank you, Reshma. Suryan, what's your thoughts on mediation and any advice to anybody listening at the back of what Mark has presented today?
Well, like Mark explained, this is a voluntary process, so it all depends on the parties that's involved in the dispute, whether it's 2 parties or multi-parties involved. If they really want to get things moved on, and you know, have a negotiated settlement that they can live with, they may not be happy with it, but to move on, then that's something that should look at. But if there's an insistence that, you know, having a neutral person, like we said, a mediator is not a decision maker, he will help the parties through the process. But if that cannot be done, then they will have to look at more formal processes of adjudication or arbitration if they're looking at ADR. Yeah.
All right, thank you. We'll just take one more question before we move to Suryan in terms of presentation. Mark, is ADR, is the rules of ADR generic to all countries? So is the rules of ADR generic, or does it like suit an ad hoc?
If I look at mediation, you would have various bodies that got mediating rules. So I would either have the CIR rules, you would have the ICC rules, So there would be various rules. The parties can themselves also set up their own rules and how they want to mediate. Under the same will apply for arbitration. The various bodies have got rules. However, you've also got the law of the land that also come into play. In terms of adjudication, where again, there are various bodies that have got the rules set up, but your contracts can set out your own specific rules. But I would always prefer to work towards the rules of a specific body, because it's been tried and tested over a long period of time, and it creates it creates a independence. So that, because you can imagine if you have a party that's got top 500 or Fortune 500 law firm, like law firm, and you got party B that's got a corner lawyer. So the imbalance will be there. So you will probably get a better deal for his client, and it could skew the arbitration agreement. You got to understand the contract doesn't be fair as long as it's legal. So I would then tend, in that under circumstances, to use the rules of the various bodies that are at play already.
Okay, thank you very much indeed. And just a final question: do you prefer face-to-face or online? One word.
I can't answer the question in one word. I prefer face-to-face because you've got a lot of interaction. However, I've also got to consider, I've caught COVID twice, so I'm very wary of face-to-face. So I'm forced to adopt a remote mediation process and practice. But face-to-face, you can interact with the person, and I think you can better to the person and try and get him to change the position a lot better. I find it. Maybe
all right. Thank you. And Warda, just quick one in terms of face-to-face or online. What's the future in Mauritius in terms of going forward, or any part in the world?
I think if the COVID-19 situation is not resolved, we will have to have more online dispute resolution. It's the next big thing that will happen. But if you're going to do that with arbitration or even with a court system, it's going to be a bit complicated, because we will have to apply the law of evidence and how would you produce documents, etc. So there will be complications, but yeah, it is something that needs to be worked on.
All right, thank you. And finally, with Reshma, how do you see the future? You've done a webinar last year, and it seems like it's escalated in terms of webinar for you. So do you see a future in that?
I think we are never going back to the way things were before. There are so many trainings being done for online dispute resolution now. And I think, picking up from what Mark was saying, online mediation, arbitration, or, any other alternative form of dispute resolution requires a different skill set. And we weren't prepared for this, right? We never knew that all of a sudden all our work will be online through, a camera. So we are adapting as well as we can. And I think, and I've seen that, organizations are coming up with training programs for ADR, because, that's the future.
All right.
But also, I also think that, we will continue to have physical hearings. There are instances where it is necessary to meet and be in the same room. And we will have to adapt.
All right. Thank you. Suryan, based on your UK experience, being a senior associate where you are, do you see online going on? Although the webinar didn't start correctly with, the videos and the PowerPoint, what's your views on online dispute resolution?
To me?
Yeah, Suryan, yeah. So I was saying, I was saying, although you had a bad start with PowerPoints and video not working,
but that's the way forward. That's the way forward. We've seen in the last 13 months, in terms of mediation, I've never had a mediation before the start of pandemic where we'll be doing online. It was always face-to-face. We'll have rooms booked up. Mediators will be walking around different rooms in caucuses, and then have a big meeting sometime, maybe not, and matters will be resolved. When it comes to adjudication, I would say probably about 1/3 of adjudications, there will be meetings held, or there will be site visits by the adjudicator. But since last year, everything, 100%, it has been online. And all the mediators, trainers, everybody is geared now towards online mediation, online ADR. And I think there's a big advantage of that, because if you have multi-parties who might be based in different jurisdictions, given, it will save a lot of time, cost of traveling. If you're required in Dubai tomorrow to attend a mediation to give evidence, you can do it online. You don't have to book hotels, look for flights. So that's one of the thing, is to minimize costs, and it's going to be very easy to be organized as well. So you could have other commitments of the meeting, but you can fit that half a day or a few hours within your calendar to fit that. And here, I mean, in England and Wales, we've had cases in adjudication, which I'm going to talk to in a minute, but I will leave it there.
Let's do that. Yeah. Let's do that, Suren. So thank you very much indeed. I'm just going to run a poll quickly because I wasn't able to run because the clashes of PowerPoint earlier. Does your contract provide for mediation? To all the participants here, 230 plus of you right now. It'd be great to get a quick engagement from you. Does your contract provide for mediation? So it'd be good to see that. I think that's a really good question from Mark, which was obviously sent before. And I think, what's your, let me just make sure, what's your experience normally, Mark? Do you see contract allowed for mediation?
I'm seeing a lot more now, but it's still not as prevalent as the other.
All right. So the results are here, and it says 50%, 49% says yes, and 51%. So that's a good one. And I'm just going to launch the second polling with Mark, and I'm just going to run and it's put the participant again. Have you participated in mediation? Be honest, be truthful. What Mark has just gone through and what Warda has talked about as well. Have you participated in mediation? So again, if you can just put your comment there as well, as most of you have already voted. I'll give you a few seconds as well, and I'm just going to end polling. So the results are here, and the result says 26% participated. A whopping 74% says they haven't participated. So thank you very much indeed. We'll move on to Suryan. I'm going to just introduce Suryan quickly, and I'm also going to share the slides. So if I can ask Mark, Warda, and Rashma to switch off their video before I do a quick introduction. I also apologize not to, can you see my slide, please? If you can put your hands up, please. I wanted to introduce more quickly because I was, again, because of the clashes of PowerPoint earlier. Just quickly, Mark is based in South Africa. He's an independent construction claim practitioner, delay analysis, expert witness, mediator, and trainer. He's also an experienced construction professional. Mark holds the following professional membership: chartered surveyor with the Royal Institute of Chartered Surveyors, arbitrator with the Royal Institution of Chartered Surveyors, fellow with the Institute of Claim Practitioners, and associate construction manager for the Chartered Institute of Building. Finally, Mark is accredited by the RICS as a commercial and civil mediator and has accepted appointment as mediator in a number of construction disputes. Mark is instructed by a number of law firms to give evidence both orally and in the form of written report as expert witness in adjudication, arbitration, litigation, dispute resolution forums on matters of delay, disruption, loss of productivity, acceleration, and concurrency that tend to arise on construction engineering project. So we've done that, and I'll just move to Suryan quickly. Suryan Ilatombi, and Suryan has got a wide variety of experience. He's a specialist construction lawyer. He has advised clients in a range of construction and engineering projects of varying size and complexity, including acting for main contractors, subcontractors, employers, construction professionals, public bodies, and developers in real-time project management, dispute avoidance, dealing with payment application, and the issue of contractual notices, as well as the resolution of all type of construction dispute. Last but not least, his experience in dispute work include acting on behalf of either referring or responding parties in over 100 construction adjudications, 7 of which we were reported at enforcement stage on a range of construction issues, including dispute under most standard form of building contract, such as JCT, NEC, ICE, and FIDI. And finally, payment dispute, delay disruption, claim extension of time, loss and expense claim, defective design and workmanship, final account, non-payment of retention, dispute, and professional negligence. So we're just going to do a quick survey before we take over Syrian. So I'm just going to ask you, the first question from Syrian is, have you been involved in adjudication? So any one of you here right now, have you been involved in adjudication before we kickstart the presentation? And education has always been a tricky topic as well. So I'm so happy and humbled to have Syrian here today as well. Already 50% of you have voted. The poll, I'm going to give you 20 seconds before we start. Syrian, what's your thought on that before I reveal the survey?
I would say, given you have probably about 250 people plus attending now, I would say probably 2/3 haven't heard of adjudication or dealt with adjudication before.
All right, so I'm going to share the result with you, and we've got 11% says involved, and a massive colossal 90% says they haven't been involved. Does that shock you?
It is shocking because we have it in many jurisdictions now. I mean, in Mauritius, for example, you've got a lot of people here use the JCT form of contract, where you do have a contractual right to adjudication there.
All right, thank you. And then we've got one more survey from you, which I'd love to run that as well. And a lot is a tricky one for the participant. Is adjudication a final means of resolving a dispute? So again, love to have your views on that. Is adjudication a final means of resolving a dispute? It'd be great to have your answers on that as well. Before, Shubhan, can you see your slide in the meantime?
Yes, I can.
Awesome, awesome. So, right, and I'm just going to end polling now and share the result with all of you. And 28% of you today says yes, it is a final means, and 72% say no. Shubhan, what do you think? And take it away, all yours.
Well, I will be speaking about that, and I will explain about both of them could be right. It could be final, depending on how parties deal with their adjudication agreement, whether they will accept an adjudicator's decision to be final and binding on them. Or if you go to a statutory adjudication, like we call it, then that's only temporarily binding, meaning it's not final. But my experience is 90% of adjudication decisions are accepted by the parties. Only about 10% of those decisions will go on to be determined, finally to be determined in arbitration or by the court.
All right, Shubhan, thank you. Take it away, and thank you.
Right, thank you. If you pass to the next slide, you've already done my introduction. Thank you very much, Anil, to have me this afternoon. I'm really delighted to speak to you guys on ADR, the new normal, and how we're doing in terms of adjudication. And like we've seen from this survey about, given the percentage of people who haven't been involved in adjudication, and I thought what I will be doing this afternoon is I'm going to give you a very basic overview of adjudication rather than bog you down with case laws, which will get you lost. So I'll keep this very brief. You can ask questions at any time, at the end of the discussion. And we maybe, you can email Anil of any new topics that you would like me to come and talk to you about, further, deeper matters in regards to adjudication. I've noted two questions that was put on the panel earlier. One is from Olay Jide, which says, under what condition can we use mediation or adjudication? Obviously, I will deal with that in my presentation. And then some anonymous candidate have asked, kindly differentiate between arbitration and adjudication. I will be dealing with our adjudication side. And obviously, when you hear Reshma at the end of this afternoon presentation, you will have a fair idea of what arbitration is about. So in terms of agenda, what I'm going to talk to you this afternoon is I'm going to explain to you what is adjudication. And in the context of statutory adjudication, how it works in England and Wales. We'll go on to explain the process of adjudication, the duties and powers of adjudicators, and finally deal with enforcement. I mean, I shall also touch on how the current worldwide pandemic has affected and change in which parties to adjudication can now resolve their disputes. Next slide, please. So, adjudication, what is it? It's not mediation, and it is not conciliation, and it is not arbitration. However, adjudication it is there to set out the same function as mediation and arbitration, and it must be remembered as the court. It is a process, it's a formal process of dispute resolution. Adjudication is no more than a contractual provision, whether this is expressly provided in your contract or implied by statutes. So what I mean by that is you will have it in most standard form of contract, and even in bespoke contract, parties would prefer to have adjudication in there contractually, rather than having matters to be dealt with arbitration or the courts. Or if you have works being done in England and Wales, then you will have statutory adjudication, which will be implied in your contract. The adjudication process is a mean by which an independent third party will make quick decision when the parties are, of course, in dispute. Next slide, please. So here, the nature of disputes, what are the sort of dispute that can be referred to adjudication? I mean, any dispute under a contract can be referred, but the most common ones would be, if you are a contractor or subcontractor under a construction contract, cash is king for you. It's the lifeblood of your project. So I would say interim payments, the first one, or any money claims, would be the common ones that will go to adjudication. And of course, you will have final account disputes, extension of time claims, delay claims, variations, and any defective works by reason of poor workmanship or design, or both. Next slide, please. So what is the objective or the objectives of adjudication? It has been, been proven very popular, often cost effective. It's a quick form of dispute resolution. It allows work to continue.
Can you see it now? Sorry, can you see it again?
Yeah, I mean, you've gone one slide too far. You need to move back one. Yeah, that's where I am now. So yeah, like I was saying, the objectives of adjudication is to allow cash to flow very quickly. It's a determination of your dispute by way of documents. And recently there's been a lot of, like I explained in the 13 months, if there were to be any hearings, all these hearings have been held remotely by the adjudicators. It has proven to be, because of the quick process, to be far cheaper than litigation. That's my personal experience over the last 12 years, what I've seen with adjudication, and far cheaper than arbitration. Some adjudication nomination bodies in the UK, like the RICS, I mean, most of them now, TEXA, RICS, the CIR, UK adjudicators, what they've done is they've set up, with the help of the Construction Industry Council, to set up low-value dispute adjudication where the fees are capped, and that's has been very popular during the pandemic. But at the end of the day, what does it do? It allows works to continue. Say, for example, in the middle of a job, and it helps help with cash flow. But in order to achieve this, what I was going to say is, for you to be able to use adjudication, you need to, if you're the referring party, making sure that you're well prepared for an adjudication and you think about it through, which I will give you some advice at the end, some tips, making sure that you know what you're going to refer to an adjudicator because of the time scales, which I'm going to talk to you about in the next slide. Next slide, please. So the key features of adjudication, two things, these three things you need to remember. It's quick, efficient, cost-effective. As I mentioned before, you have a determination by an adjudicator within a very tight timetable of 28 days, and that time starts from the day you've referred the dispute. That time can be extended unilaterally by the referring party for a period of up to 14 days. Normally, the adjudicator will ask for that time, and or if it's going to go beyond the 42 days total, then it has to be with the agreements of both parties. In the UK, I'm just, just to give you an idea, about more than half, about 55% of adjudicators' decisions are actually reached within the 28 days limit. The second key feature of adjudication decision is that these are temporarily binding. That's what the statute provides in England and Wales. It is not binding at once or for an all basis, as is the case with litigation and arbitration. And I hope this answers the question that's been asked earlier. And it is known as a rough and ready form of dispute resolution. It's very rough. If you think, I'll come to the timetable in a minute, but generally an adjudicator will have no more than 10 to 14 days to decide on paper on a project on a massive dispute. And this can range from £10,000 to up to £10 million, if not more. There's no limit. And you're dealing with big claims here in terms of monetary value. And this is regarded as rough and ready in that tight timetable. But it goes with the saying, what we say about the very nature of adjudication, which is, you know what, pay now, pay first, and then you can argue later. That's why it's temporary binding. You can argue the full, your full defense, the full evidence later in an arbitration or court litigation. Next slide, please. This case, I thought it's worth mentioning. One of the cases that was reported last year in the TCC. TCC is the Technology and Construction Court. It has the main court within the High Court in London, and they have a few court centres like in Bristol, Birmingham, in England. This case, there was an adjudication that was started. Milcris, it's a bit blurry, the slide, Anil. I hope the guests can view it. But the adjudication was started during the first few months of the pandemic last year. Solicitors for the referring party tried to stop it. And what they did, they went to the TCC court and applied for an injunction. And the reason for applying for the injunction by saying that they weren't able to reach their managing director of the company to obtain instructions or contact their QS who was actually furloughed. So they couldn't obtain the necessary evidence. There was not enough time for them to instruct a surveyor to have a proper site visit. But unfortunately, what the court did, they rejected that injunction application and gave clear guidance that even if it's a tough timetable and the pandemic, it's there. Everything, you've got all the facilities. We have technology methods. The adjudication can be held remotely. That's what's been held by the judge. And documents can be scanned. So you have to look all the facilities like we're doing now with our webinar, how we're providing, the slides, the handouts, questions being asked. And yes, so that shows, that kind of paved the way during the last year's pandemic to show that nothing can stop adjudication along the way. Next slide, please. So what is, I keep mentioning right from the start about what is statutory adjudication. the adjudication, which takes place under the Housing Grants, Construction and Regeneration Act 1996. And as you will see the date there, this act has been amended. And on the 24th of July this year, 2021, it will be 25 years since this act was passed and received royal assent. It came into effect in May 1998. What the Act does, it requires a construction contract to contain payment provisions and the right to adjudicate any dispute under Section 108, and meaning that any party to a construction contract has a right to refer any dispute at any time. But it's a dispute. I'll come to that in a second. But so if your contract does not provide for adjudication provision or payment provisions, then the default position is the amended scheme for construction contracts, England and Wales, Regulation 1998. Those terms in the scheme will be implied in your contract. And what the scheme does, it contains a detailed payment provisions, how we apply in terms of payment notices, payless notices, including the right to serve payless notices, provide you a date for final payment under the contract, as well as a detailed procedure for adjudication. Next slide, please. So the Construction Act, just quickly, briefly on this, it applies to, provides that what is a construction contract. This is defined in Section 104 of the contract, which provides that a construction contract is any agreement for the carrying out of construction operations, arranging for the carrying out of construction operation that could include labors of others, which would be used for carrying those construction operation. I'm not going to recite all the sections of the Act. You can look at it yourself online. It's widely available, but you would see that there would be specific operations that are excluded from the Act. For example, PFI contracts, employment contracts, or drilling for oil, for example. And one thing to note is residential occupiers. So any building work which is eventually going to be used as a residence of the party, that has also been excluded by Section 106 of the Act. And finally, if the Act applies to your contract, then a party has a right to refer a dispute to adjudication at any time. Next slide, please. As I mentioned earlier, the scheme was brought in. It was amended in 2009. It was introduced under the Act. I've already told you about the detailed procedure about adjudication, and that starts from the time that you issue a notice of adjudication, the selection and appointment of an adjudicator. It deals with how you do that, and right through when you refer the dispute in terms of submissions, the giving of an adjudication decision, which is 28 days from the date of referral, and how it is dealt in terms of enforcement of adjudication decision. Next slide, please. So quickly, the process. The process, I would say, you can see on your slide here, I've listed about 5 items which you can read, but I would say that the first step before you start any adjudication, you need to ensure that the contract is a construction contract as defined by the Act, if you're dealing with the Housing Grant Act of England and Wales. Ensure that the construction operation under the Act are covered by those provisions under the Act. Check whether the other party is a residential occupier or not, and ensure that there is an agreement in writing as defined by Section 107 under the Act. And the other step I was going to say, there was a question earlier, is to make sure that there is a dispute between the parties. A dispute meaning one dispute. Case law in England and Wales says that you cannot refer more than one dispute at a time in adjudication to adjudication, unless, of course, if both parties have agreed they've got more than one dispute and they've agreed to refer all these disputes put together into one adjudication before an adjudicator. By my experience, is 99% of the adjudications that's been referred are never been done, have never been done by consent. They're normally done by one party. That's why they're in dispute in the first place. And one thing you need to understand, so a dispute can encompass several claims. So you can have a final account dispute, which will deal with extension of time claims, defects, variations, other issues. That's, to me, at the end of the day, it's what's properly due from one party to another. So that's one dispute. Rather than if you're dealing with, under a contract, something to do with planning and then interim payment, that would probably be, depending on the circumstances, to disputes, and you can't refer both of them at the same time. So the next step on your slide is you need to draft and prepare notice of adjudication. You have to serve this on all the parties that are to the dispute in writing. The next stage is for you to select and appoint an adjudicator. That's normally done, in some contracts, you will either have a nominated adjudicator, or at least minimum, for example, the JCT, you will have a list of adjudicator nomination bodies like the RICS, CIR, for example, where you will select who to appoint. If there's no nomination body, then you can select whoever you want, if that's not stated in your contract. But one thing to remember, which is always, is still a case after 25 years, we've had a case recently in the courts, is to always go and make your request for the appointment of an adjudicator only after you've served the notice. If you by accident send your request to appoint an adjudicator before you've served the notice, it means the adjudicator would have been appointed wrongly, and that adjudication decision will have no value to you. Next is you have to serve a referral notice once your adjudicator has been appointed, and you have, according to the scheme and the contract provided and the Act as well, there's a time limit, a deadline for you to serve your referral. So you can't serve a notice and leave it there and saying, I'm going to serve a referral notice whenever I want to. You have a deadline of 7 days, so that has to be done within 7 days. And with your referral notice, you must attach all the documentation that you intend to rely upon, evidence, drawings, programs, as you would normally do. So this is a very tight timetable. And in terms of when I'm acting for parties, if I'm referring, I would get all my stuff together, all the documentation, evidence, bundles, referral notice first. Then I'll prepare the notice of intention finally, because then there won't be any pressure. By serving a notice, you've got limited time to prepare for the full referral. The adjudicator will have 28 days maximum, but I explained earlier, that's subject to extension of 14 days by the referring party, by which he or she should be providing his decision. In those 28 days, the other party will have the opportunity to make submissions and replies as a defense, and depending on adjudicators, she may allow further rounds of the submissions. What they tend to do is the adjudicator will tend to leave a number of days for them to be able to look at all the evidence and write up their decision. Next slide, please, Anil.
So, Surya, just quickly, we've got a few minutes to wrap up.
Yeah, nearly there. I think that's probably the last one. Now, enforcement. I will stick to this slide, which is very short. Normally, at the end of an adjudication decision, there will be an award made in favor of the winning party. And the losing party will have to pay if it's money or if it's a performance of something. a declaration, they must comply with those declarations. So if the unsuccessful party refuses to comply, then under the Construction Act in England and Wales, we have a specialist fast-track procedure where you can go and enforce your decision if you're the winning party in the technology and construction courts. Generally, if you issue an application today, you could be appearing in front of a judge within the next 6 weeks by the time you've issued the application for summary judgment. And time is a bridge for the other side to serve a defense. But one thing to note is very rarely, it's very rare for the TCC, the Technology and Construction Court, not to enforce the adjudicator's decision. This is basically because of the pay now and argue later, which is the central objective of the Construction Act. But that said, cases have actually been challenged in the past where the unsuccessful party can prove that either the adjudicator has been biased, there's conflict of interest, or they've exceeded their jurisdiction, or they had no jurisdiction at all. I was planning to talk a bit about jurisdiction, but I will leave that for another time, given we're running out of time now. It's a big topic in itself, dealing with two types of jurisdiction, threshold and internal jurisdiction. Or there's no clear decision that can be reached that is capable of performance, illegality, bribe, and finally the breach of natural justice. To put that in simple terms, breach of natural justice, what is normally argued is one party have not been given the opportunity to make that, provided they didn't have a fair trial, is to make submissions or present a defense where the adjudicators have refused to do that. Next slide, please. I think that's the end of my presentation. If you have any questions, I'm happy to take part now with the panel. But thank you very much for listening to me.
Thank you very much indeed. Can we have a big round of applause for Suryan quickly? What we will do, we will move on to Reshma, and then we'll pick up the question. So, and I think we can wrap up all the questions in one hit. So, Suryan, if I can have you to switch off your video, please, and then I will get Reshma back on track, please, for the presentation on arbitration before. So we've got about 25 minutes left before we conclude the 22 minutes left before we conclude the presentation. So Reshma, can we have you please on the, just making sure we've got Reshma here as I share my screen and my video. So just making sure I've got Reshma here. Right. Share screen, there you go, here you go, here we go. So just making sure I've got my video, and Reshma, if I can have your video, please. And I'm going to introduce Reshma quickly. Reshma, are you there? Trying to find Reshma. Can you hear us, Suryan, Mark and Warda?
Yes, I can hear you.
I can hear you.
Yeah,
Reshma is mute.
Yeah, I can. Yeah, so Reshma's back. So I'm just going to introduce Reshma quickly. Reshma, you can see my slide, right?
Yes, I can.
Okay, so we've got Reshma Ugara, who's a fellow of the CIOB. Just making sure I've got Reshma. It's a long step. I'm just going to need to make sure I quickly wrap up. Reshma Ugara practices as a legal counsel and arbitrator. She's a dual qualified lawyer admitted to practice law in Mauritius and in England and Wales. She's also a fellow of the Chartered Institute Arbitrator. She recently founded Neom Legal, a legal consultancy firm where she focuses on construction and commercial arbitration matters. She assists business-based in or interested in doing business in the Middle East and Africa, including Mauritius. Reshma has been involved in high-value complex arbitration and litigation in Mauritius, the Middle East, and in the UK, many of which were construction disputes. She has also previously worked as a construction and arbitration associate at various law firms in the Middle East, where she advised on and resolved dispute-related matters to some of the largest construction projects in the world, such as the construction of World Cup Stadium, infrastructure project, hotel, gated communities, and theme park, among others. And finally, she has been involved in ad hoc arbitration, as well as arbitration under various institutional rules, such as ICC, DIFC, HICC, DIC, QICCA, and ADCCAC rule held in various jurisdictions, including Mauritius, England, and Wales, UAE, Qatar, Bahrain, Kuwait, and Oman. In itself, this is a CPD talk in itself. It's already a presentation for me. But I'm going to stop now, and I'm going to ask Reshma to share. I'm glad you still have, I think Reshma was saying, I'm the last speaker. There might be nobody to listen to me. You've got 200 plus looking forward on arbitration. In the meantime, while you're sharing as well, I'm just going to share the poll here. And if you can please vote, all the participants, have you previously been involved in an arbitration? At least that's going to be putting a bit of context to Reshma's presentation in a minute, but have you been involved in an arbitration? Be great to have your views on that before we go into panel discussion afterwards. So I'm going to share the result with you now, Reshma, and the results are here. And it's 17% yes, but a whopping 83% says they haven't been involved. So I'm just going to make that one, and there's one more survey from you. And again, this is a good one. Is arbitration a final method of dispute resolution? So again, it'd be great to have your views on that one. Is arbitration a final method of dispute resolution, before we move on to Reshma Ogara, fellow of the CIOB? So I'm just gonna stop polling now. 47% of you have voted. I'm just gonna give you a few more seconds. And it's kind of 50-50 really. So I'm just gonna end the polling here. And Reshma, this is for you. 52% says yes, it's the final method of this resolution. And 48% says no. Take it away, and what's your thoughts?
Thank you, Anil. Thank you very much for conducting those polls, and also for having me today. Regarding whether arbitration is a final method of dispute resolution, I'll say please hang on here, and you'll find the answer to that in the next few slides, I promise. I think we've had some excellent presentations today, and thank you to Mark, Warda, and Suryan for that. Well, and we also seem to be having a very engaging audience today, which is wonderful. Okay, so I will be focusing on three main areas today. So I'll be speaking about the challenges caused by the pandemic, the appropriateness of arbitration, and the new normal of arbitration. And just I won't be going into too much detail about arbitration. I have a webinar on that already, which was on arbitration in the construction industry, so which is on YouTube, I think, Anil. So you're very welcome to go and watch that. Today we'll be touching on a few points only. All right, so I'll be talking about these three things, and let's start. So to start with, I'll go over the definition of arbitration. So as you know, I think Anil mentioned earlier, the Chartered Institute of Arbitrators, which is the leading training organization for dispute avoidance and dispute management, well, I quote from them, and they say that arbitration is a non-judicial process for the settlement of disputes where an independent third party, an adjudicator, makes a binding decision. The role of an arbitrator is similar to that of a judge, though the procedures are less formal and arbitrators are often an expert in their own right. Now, just to pick up on some of the characteristics in this definition, first of all, we can see that arbitration is non-judicial, which means that it's not conducted within or by the courts. It's conducted separately and outside of the court system. Secondly, arbitration involves an independent third-party decision maker. So instead of a judge or a panel of judges, it is a third party, and who we call an arbitrator. And if it's more than one, there'll be a panel of arbitrators who will make a decision on the parties' disputes. Thirdly, arbitration results in a binding decision. And to answer your question, it results in a binding and final decision. And what this means is that parties generally have to accept the decision of the arbitrator or the panel of arbitrators, which we refer to as an arbitral award. I'm sorry, sorry, go back to that. All right, so yes, and as you have just heard, adjudication in contrast is a binding, is binding, but is not necessarily final unless the parties agree that it would be a final method of dispute resolution. Now, well, the fourth characteristics is that arbitration procedures tend to be less formal than court proceedings, and arbitrators are often experts in their own right, which means that they can be industry experts such as construction professionals, financial experts, etc. So generally, arbitration is used in many types of commercial contracts. It's very prevalent in cross-border international commercial contracts and construction contracts in particular. But we also see arbitration in other sectors such as the oil and gas industry, TMT, technology, media, and telecommunications, and so on. Now, we now come to the first part of my presentation, and where I wanted to look at the challenges with which the pandemic has brought along with it, and which affect dispute resolution processes as a whole. We've heard some of them from Mark, Warda, and Surian, but this is, let's say that this is a consolidation of all that. So first of all, I believe that we've all experienced restrictions on our freedom of movement. A lot of countries have imposed health-related precautionary measures, such as prohibition on international travel, lockdowns, physical distancing requirements, and so on. Well, these measures have in turn affected the supply chains across the world. They've also affected the time schedule and cost of many ongoing projects. So for example, there's been lack of staff and workers on site, unavailability of materials, shipping and transportation delays, etc. And the travel restrictions that are aimed at limiting the spread of the virus have made it difficult to access workplaces and construction sites. And even where travel restrictions are lifted or reduced to address the health and safety risks caused by the pandemic, contractors have had to limit the number of individuals who are working on site. And this, this has been causing delays and additional costs for the construction industry. Now, because of these troubles, certain suppliers or subcontractors and contractors have been forced into liquidation. For example, in the UAE, this happened to a large construction company, which has quite a few disputes in the courts and potentially in arbitration as well. And all these raise several legal issues. And like Warda said earlier, we are receiving more and more instructions to advise on disputes and conflicts, which are based, based on the jurisdiction can center around force majeure, change in law, government controls, frustration, impossibility, hardship, and so on. Secondly, with the lockdowns, and the health-related precautionary measures, courts across the world are operating at a reduced capacity or simply closed. A lot of proceedings are being postponed and so on. While I know that's the case in Mauritius, I have to say though that in the Middle East, courts have been dealing with the situation quite well, especially in the UAE and Saudi where I practice. Courts are operating at almost full capacity through online hearings. And my understanding is that this is working because witness evidence is not given at all court hearings. And it's much less compared to common law jurisdictions. But generally in the world, courts have been slow to catch up. And in the UK, I understand that's because of increasing pressures to deal with urgent cases such as criminal action. So because of all this, because of the pressure on the courts, it's expected that people and businesses are turning to alternative methods of dispute resolution, such as mediation, adjudication, arbitration, and there are many others. Now, Thirdly, the pandemic has also caused disruptions in postal and courier services. And again, this can be an impediment for the service of documents in litigation proceedings, and sometimes even in arbitration proceedings. This is because in litigation, especially, hard copy documents are required to be served, and documents have to be signed by multiple persons located in different places and sometimes different countries. Right. So we now come to the second part of my presentation, but before we go into the characteristics of arbitration to assess its appropriateness to the current situation, I would like to make sure that we all have a broad understanding of where arbitration fits in the whole range of dispute prevention, avoidance, and resolution methods available. Right, so I wanted to share with you this dispute prevention, avoidance, and resolution continuum that I have created, or the DPAR continuum, as I like to call it. As I said earlier, I'm very passionate about dispute prevention and avoidance, and I'm currently doing some research about the most effective ways to deal with disputes in the construction industry. And hopefully I can share the results of that with you next year. Now, you've heard from Warda earlier about the necessity to have strong contracts. And in my view, your contracts can be a very impactful tool for dispute prevention. When you're entering into a contractual relationship and there's no conflict or dispute in existence, but you're actually putting in place preventive strategies so as to prevent a conflict or a dispute. And you can do that by having balanced and strong contracts, by operating those contracts effectively, and by addressing any conflicts promptly through clarification or negotiation, as we heard earlier. Negotiation is actually something that can be a means to resolve a dispute, which can be used at any stage of this continuum, as you will see. Now, there's also the dispute avoidance stage, where a conflict has arisen, but it hasn't escalated into a big dispute yet, and there's still hope that it could be resolved. You can still mitigate its effects and end it by employing softer alternative methods of dispute resolution. You've heard about mediation from Mark earlier, and there are also other methods such as formal negotiation, mutual evaluation, conciliation, and so on. And then there's the dispute resolution stage. We heard about adjudication from Surin earlier, and internationally we use what I would say is a variation of adjudication, which are dispute boards. And for me, dispute boards are a hybrid dispute resolution strategy. And statistics show that they are very effective in avoiding and preventing disputes, as by the mere fact that there's a dispute board standing, parties are discouraged from getting into a dispute. Now, in my view, it is only if the dispute prevention and avoidance methods do not work, or you feel that there's really no chance of succeeding, that you should escalate a dispute through to the court or in arbitration. And as I think we mentioned this before, court litigation and its alternative, that is arbitration, should really be your last resort, as they tend to be more complex, they take longer, and depending on the case, they can be more costly too. Okay, so appropriateness of arbitration. So let's assume that your dispute prevention and avoidance methods didn't work. Then the court would be your default mechanism for resolving a contractual dispute. But parties can choose to resolve the dispute in arbitration if they have contractually agreed to do so. And they would normally do that at the time of entering into their contract, but they could also do so anytime after, and they could even agree to arbitrate at the time where they have the dispute. As I mentioned before, courts are overloaded, not functioning at full capacity, or in some instances even closed. So if parties are in dispute, it does make sense for them to consider arbitration in order to obtain a quick, binding and final resolution to their dispute. Right, so to help you make your decision about whether to choose court or arbitration, let's go quickly over the general characteristics of arbitration. So we talked earlier about how in arbitration parties choose their decision maker. They can nominate their arbitrator, whereas in court they get allocated a judge or a panel of judges. So we also talked about how in arbitration there's little scope for appeal, but in the court process there is a system of appeal where decisions of a lower court can be appealed to a higher court. There's usually a three-tiered court process with at least 2 levels of appeal. Whereas in arbitration, there are no or very limited rights of appeal. Generally, a party may only apply to set aside the decision of an arbitral tribunal on limited public policy grounds. Now, we also talked about the formality of the court process as opposed to arbitration, which is more flexible. I mean, in an arbitration, the process is guided by the parties' choice and their arbitration agreement, in which they select the rules that will govern their arbitration. And usually those rules are very flexible, and the parties and the arbitrators have the opportunity to further decide on how the arbitration should be conducted. So, for example, they can decide when to submit pleadings, whether or not to have a document production process, whether or not to have a hearing, and whether or not to have experts, etc. Arbitration is also conducted in a more relaxed environment with less strict decorum compared to court. So, for example, there's less formalities in an arbitration, no gavel is used, the legal representatives and the arbitrators do not have to wear a court robe, etc. And with the pandemic, we are seeing the benefits of the flexibility and agility of the arbitral procedure and the process where parties can really influence the manner of conducting arbitration proceedings. And as we've heard, many hearings are being conducted remotely or virtually, and parties can agree on the technology to be used and the manner of giving evidence, etc. And I will talk more about this later. Speed versus delays. Well, generally it takes less time for a case to run its course for an arbitration process compared to a court process. In court, generally there are at least 2 levels of appeal, like we said before. But in arbitration, since the parties have control over the process, and in the case of institutional arbitration, the process is monitored by an institution which focuses on efficiency. A typical arbitration is completed within a year to 3 years, maybe max, compared to the court process, which can take up to 5 to 10 years to conclude. And with the pandemic, cases are expected to take even longer than that. And it is possible to go for expedited arbitration proceedings where an arbitration must be completed within 6 months or 3 months, and in some cases even 80 days. Now, while arbitration can be more expensive than the courts, in the current climate, there is this perception that there is a huge opportunity cost for delays, which parties experience in court, and which outweigh the cost of arbitration by a lot. And besides, a lot of institutions now have expedited proceedings, like I said, which take less time and cost less. So it may also cost less actually if you decide to arbitrate under the rules of your local institution as opposed to international institutions. Now, so lastly, I wanted to talk about cost and complexity, and I've gone over costs. And complexity, arbitrations can be quite complex, and an example is construction disputes, and courts do not necessarily have the technical expertise to deal with such disputes. Whereas, as we discussed earlier, parties have the choice, they can choose their arbitrators and they can pick someone who has both industry experience and legal expertise. Well, I hope this will help you to make your choice between court and arbitration. Now, going quickly over...
Reshma, you've got a few minutes to wrap up.
Yes, sure. I will be quick, I promise. Well, yes, so quickly about the impact of the pandemic on arbitration. It seems that despite the pandemic, the demand for arbitration remains high. And last year, many arbitral institutions broke their records of the number of filings, such as the ICC, the SCIA, the Singapore International Arbitration Center, Hong Kong International Arbitration Center, I did not find any information or statistics on when the businesses are choosing arbitration over the courts, but there is a perception that this may be the case. And also with the pandemic, there is an expectation that there will be a rise in disputes overall and hence arbitration. Now, I think I will skip a bit. Well, okay, so coming now to how institutions have reacted. They did react very quickly after the outbreak of the pandemic, and some of them issued public statements and guidance notes as early as April last year. You know, they actually, I mean, most institutions now require and recommend that communications with them are conducted by email, and that documents and applications are filed electronically without the need for hard copies. Like I said, they have also issued guidance notes on how to deal with arbitration proceedings in the current climate. And it's also interesting to note that some institutions have even proceeded or initiated expansion plans during the pandemic. And for example, SIAC opened a new office in New York, and the ICC announced the opening of a new case management office in Abu Dhabi in April, which is you know, this month. Now, when it comes to filings, well, long before the pandemic, arbitral tribunals had already started to move exclusively to email communication and electronic filing of documents. Now, with the pandemic, we are seeing an acceleration of that, and arbitral tribunals and arbitrators who were less inclined to do so are now accepting electronic filings of documents. And also using electronic signature, and as in other industries, you know, this has really accelerated the adoption of technology in arbitration, but also in the legal sector generally. Now, when it comes to time limits for the filing of documents, there are circumstances where people have not been able to complete filings on time because they were not able to work, or documents could not be accessed, or experts were not able to access construction sites to prepare the report. Personally, I had a case where my client's documents from 5 years ago were archived in an inaccessible location like a red zone, and they could not retrieve the documents immediately. So what arbitral tribunals are expected to assess these situations on a case-by-case basis to see whether these disruptions justify any delays in the progress of arbitration. So it's not as of right, you don't get extensions as of right, they're all assessed as they used to be. You'll need to demonstrate why you are not able to file on time, etc. And then we come to virtual hearings. Of course, we've all heard that you know, more hearings are being conducted online now, and 2020 has been declared the year when arbitration hearings went virtual. Now, arbitrations are also being conducted. I mean, when we say virtual, there's also a lot of hybrid arbitrations. And personally, all of my arbitrations have been conducted virtually or partly virtually since March 2020. So basically, just to give you a picture, we would all be, you know, on Zoom or Teams, or you know, there may be some people present in a certain location, whereas others dialing through video conference. And again, there have been specific guidance issued by institutions on the conduct of virtual hearings. Now, there has been some debate over whether you know, this may cause an issue when it comes to due process, etc. And there has been a court judgment on the issue rendered by the Supreme Court of Austria, where one of the parties objected to having a virtual hearing and then challenged the arbitral award on the basis that this was in violation of fundamental due process principles. Namely the right to a fair trial and the right to be heard. Well, interestingly, the court held that there was no such violation in that case. And on the contrary, technology offers protectionist mechanisms that may go beyond those available in typical physical proceedings, such as recording the witness's evidence, being able to closely observe the person speaking, etc. Now, to conclude, I think arbitration in the new normal is ongoing and increasing. It's potentially more efficient through the use of technology. Less travel is required, which also means less hours and less per diems to pay for. There is also no need for printing as many documents are produced electronically, and we're using electronic bundles. And I think as a result of that, and through the digitalization of proceedings, we're getting an added bonus for the planet as well. We're on our way towards greener arbitrations, which are more sustainable for the environment. Well, I hope that that was short enough, Anil, and helpful. Well, I'd be happy to answer your questions.
Okay, thank you, Reshma, for this amazing presentation. If you can just stop your video, and if I can have Mark, Suren and Warda quickly. It's already 2 hours and 30 minutes, and it was supposed to be 15 minutes each. And that's the beauty with the lawyers. They've just got so much to share. And I think Mark and Suren, if I can have you quickly, we're just going to pick up a few questions before we terminate in 5 minutes. So Suren, I think there was a question for you on arbitration, when Jafar said about on jurisdiction in enforcing adjudication. Quickly, what's your thought on that?
So just briefly, I'll try to be brief. It's a big topic in itself, but the starting point that you need to consider jurisdiction is not only at an enforcement level. You need to look at it right from the start of an adjudication. What is generally happen is a responding party will tend to challenge an adjudication from the start by arguing, for example, if, before I give the different ways of challenging a jurisdiction, is what is the purpose of challenging jurisdiction? If you can successfully do that, then the whole process stops, because the adjudicator cannot go and reach an enforceable decision without the requisite jurisdiction. And the same will happen after you've had the decision. You can go and challenge it in court saying, I'm not paying, or I'm not going to comply with the actual performance that I've been asked to do, because the adjudicator who made that decision did not have the jurisdiction. Jurisdiction, what it means in the legal sense, is you have the power. You've complied with all the requirements where you, as an adjudicator, can look at a dispute and provide a decision. So quickly again, they've asked me to say it briefly, but a few ways of doing it is, there are two aspects. One is threshold, which is whether the adjudicator has got the decision to start the adjudication at all, or the other one is internal, it's concerned with the dispute itself. So looking at threshold, things that can happen is, as I mentioned earlier, an adjudicator has been appointed before you've served your notice. There's a requirement. You have to serve the notice and then appoint the adjudicator. So that would fail. The second would be if your contract has a nominated body to appoint the adjudicator, the RICS, for example, and you've gone to a different institution, the CIR or the UK adjudicators, it means the adjudicator has not properly been appointed. More crucially, which I should have said, is the actual contract. We're trying to do an adjudication. If it's not a bespoke JCT contract, for example, sorry, a standard form of contract, is there's no construction contract at all. For example, it's a house extension, it's a contract with the residential occupier, they're not covered under statutory or adjudication, so the adjudicator cannot start that adjudication. That's threshold. In terms of the internal jurisdiction, I had it listed in my last slide, which would be, for example, the adjudicator, he didn't reach a decision that's capable of performance. He has exceeded his jurisdiction, meaning he's decided on matters that was not referred to him. And there's element of bias, or he's breached the natural rules of natural justice by not giving the other side to answer. So that's, you know, in a nutshell, what jurisdiction is all about.
All right.
I will say one final word that people need to remember always is an adjudicator, given that the tight timetable of 28 days, he can ascertain the facts and the law, and he's entitled to get the facts wrong. So even if he gets the facts wrong, the adjudication decision will be enforced.
Wow.
Even if he gets the law wrong, that's another debate, the adjudicator's decision will be enforced, as long as he's answered the right question that has been posed to him.
Wow. All right.
I hope that answers the question. That's
all right. Thank you. Thank you very much indeed. We've got a few questions on the tab which we want to conclude now. We've got Carmen Sita in the UAE. So many thanks to all the panelists for another amazing and very informative webinar. Keep well, keep safe. Thank you for that one. We've got a question from Andish quickly, and I'm going to go to Warda on this one. If someone does not agree with a mediation, arbitration, adjudication, and decide to go to the court, will these decisions be considered, or will it be a fresh case?
Well, it really depends. So if you have an arbitration in Mauritius as the law stands and you have an award, you will not be able to go to a court. The court will reject that decision because it has been subject to an arbitral award. What you can do is you can challenge the arbitration, but there are only specific, some very limited situations when you can challenge an arbitral decision. As for mediation, well, following mediation, you will have a settlement agreement, and then yes, if you want to dispute your settlement agreement, then you will have to go to court.
Okay, all right, thank you. Before I finish off with Mark, Reshma, there's a question from Kavri Raj. He's saying, when is the arbitrator nominated for a contract? When is the arbitrator nominated on a contract?
Well, generally, the arbitrator is nominated at the point where the arbitration is filed. So in the case of a panel of arbitrators, if it's in institutional arbitration, then the practice is that the claimant will nominate one arbitrator, the respondent will nominate another arbitrator, and then the two arbitrators will nominate the chair, and then the arbitrators will be appointed by the institution. There is a distinction between nomination and appointment. The parties do not appoint the arbitrators, they nominate the person they want, and then the institution appoints the arbitrators.
All right, thank you. I've got Mark to finish off, and then I've got a few minutes of a slide to conclude and then get your word of wisdom as we get to 2 hours and 45 minutes of CPD. Mark, just quickly, what's your overview from what you've seen from Warda to the local laws, to Reshma, and to Sue in the UK? What's your overview and what's the advice you want to give to participants? I know you're an expert in FIDIC. What's your advice quickly on what you've seen today?
Don't get into a dispute situation. Avoid disputes. It can become costly, and for the lawyers like ourselves, we don't mind, but it's all about dispute avoidance. Focus on the project, build what you need to build, and avoid disputes. But having said that, always ensure you have a strong commercial and legal team supporting you to assist you upfront in avoiding disputes. Because you might spend a lot of money upfront, but in the long run, it becomes a lot more costlier when the disputes are messy and can drag out for years and years and years. That's my voice.
If you, if you don't mind, Anil, I'll just second that.
We'll come back to you. We'll come back to you. We'll come back to you on the word of wisdom. I need to just do a polling, few slides, and we'll come back to you to get your word of wisdom. Sure. I need to share this quickly, and this is a really important question to all the participants today. Are you inspired to get involved in ADR as part of your professional career, having listened to Warda, Suryan, Reshma, and Mark? I was going to say Neil because I was looking at my face, but Reshma, Warda, Suryan, and Mark. So are you inspired to get involved as part of it? I definitely want to do it. I just don't know if I've got the time because these guys are just way ahead in terms of where they are. So it's great to have you as role model and inspiration for all of us. We've got about 61%, 62% now voted. Are you inspired to get involved in what we've seen today of 2 hours and 45 minutes of talk? And it's incredible. And these guys were just going to talk for 15 minutes each. And there we go. So hopefully we'll have more webinar with these guys. And I'm just going to end polling now. 65% of you have voted. And what do you think? Reshma, what do you think? Do you think the audience will be inspired by you today?
I think they will be inspired by Warda and Mark.
And okay, and what do you think, Suryan?
Your question is about getting involved in ADR. I think this is a good thing to do, the future.
Absolutely. Thank you, Suryan. And Warda, what do you think? Do you think the participant has voted for to get inspired by you? You're on mute, Warda.
I think we'll have 100% inspiration today.
Wow. Okay, very optimistic there, Warda. Thank you. And Mark?
I think there will be a okay, here we go.
So,
92. Almost right.
At least you know the poll has not been rigged. It's open, transparent. 92% right now, which is 100 plus, 110 plus, have been inspired by your talk. 8% are either sleepy because it's quite late in Mauritius, or they're hungry, right? So obviously we'll get back to them on that one. I've got a few slides before we come back to you on the word. Stay where you are. But thank you. Can you have a round of applause for everyone, please, on this incredible 92% has been inspired today. Fantastic. And I'm sure there'll be more to come. So I've got a few things to share with you. And I just want to make sure I've got one more slide before I conclude. So I'm just going to share the slide with you now before we conclude on this 2 hour and 45 minutes. So I'm just going to share my slide quickly. And we've got here, can you see my slide, the panelists there?
Yes.
Okay, so I'm just going to share the video quickly as well. So I think many of you are into construction industry. Don't forget to get this book from Andy Hewitt, who is a very good friend of Mark. Reshma know Andy as well, who is probably one of the guru. And the book talk about failure to provide notices in the correct format is one of the biggest mistakes made by parties and those appointed to administer a FIDIC contract. We've just talked about it as well. This book examines each clause of the FIDIC red, yellow, and silver form of contract that requires notices to be given by the contractor, the employer, and the engineer. It contains explanation of why and under what circumstances each notice is required and provide a real-world example of typical notices for each clauses. And also there was a foreword by Dr. Cyril on Andy's book, and he goes on to say, this is a must-have and go-to book for any contractor, solicitor, barrister, engineers, and employer who uses FIDIC contract, and its information will save time and money for all those who use it. I highly recommend this. And I think we mentioned about, this was a quote which I shared numerous times by Tony Bingham. And he had a blog on Building Magazine, and he talked about emergency government guidance on contract urges to behave responsibly during the pandemic, but why only now? So he talked about, as to dispute in particular, the government will strongly encourage parties to seek to resolve any emergency contractual issues responsibly through negotiation, mediation, or fast-track mechanism before these escalate into formal intractable dispute. He goes on to say, for example, the RICS has developed the low-value dispute model adjudication procedures. Let me say at once that this device is already working well, which Sharon has just touched on. And finally, he goes on to say, if there's any good to come out of this dreadful episode of COVID-19, which we are currently going still, it may well include the good faith and fair dealing attitude. There's a real possibility of the dispute deciders here about applying standard of fairness to contract with an eye to the current emergency and the idea becoming embedded thereafter. Who knows? Finally, let's act in good faith always, not just during COVID-19. So this has been reinforced by all the lawyers today. We've done the final survey, and I've got this for you, which I shared out when Reshma did the presentation. She's smiling, I can see. I love learning. I'm just addicted to knowledge. It just like make me happy. It keeps me motivated. So I'm just going to share a video with you quickly before we get the final thought of all the speakers. So I just want to make sure I've got to share that. And if you can hear the sound and see the images as well, please let me know. And then we're just going to share that now. So off we go, and off we go. Here we go. Okay, so thank you for that. I'm sure many of you has been inspired by this. I'm just going to go back to the slide before we conclude. I just want to say a quick thank you to Warda, Mark, Syrian, and I'm just going to ask you a very final question after this. I'm super impressed by our teamwork. I think we're going to be sad after this event today because we really communicated on WhatsApp and I've created really nice bonding. So thank you for your willingness to give back on a global scale, armed with your extraordinary skill, expertise, energy, and determination to keep sharing consistently your experience, wisdom, knowledge, and more importantly, for being a role model to all of us. So from the bottom of our heart and on behalf of all participants today, we still got 170 watching you guys after almost 3 hours. So thank you for this informative and engaging webinar, despite the time differences between us all, immensely humble. So just quickly, next week we'll have the webinar on the acoustic for the built environment. Once again, a massive groundbreaking and a first in Mauritius. So it's gonna be great to watch that as well. Take care, be safe, make sure you have your 2 meter distance. It's not 1 meter anymore, it's 2 meters. So make sure you've got that as well. And again, massive thank you. So I'm just gonna go back to the speakers and have their final thoughts before we conclude. Already we've got Nathir saying many thanks to all the panelists for their amazing talk. Thank you all the panelists again from Balgobin, much appreciated. So Reshma, final, I know you wanted to talk. We've got 7 minutes left, but I want to ask you a really nice question. So Reshma, tell me what you wanted to talk, and then I need to ask you a final question.
Well, no, I just wanted to second Mark to say that your dispute prevention and avoidance strategies are so important. It's better that you, invest money in that so that you don't have to, then later spend a lot of money on disputes and lawyers, like he said. And I also wanted to add that lawyers and industry professionals, I mean, it's only when lawyers and industry professionals work together that you get the best result on your construction projects. And I think that's the spirit with which you should be going into your contract. Make sure that you have the technical expertise, make sure you have the legal expertise reviewing that as well.
Okay, thank you, Reshma. And Reshma, just quickly, for everyone watching you, is the ladies watching you or the gents watching you, what's your advice to everybody in terms of how did you get where you are today in terms of being a lawyer, a construction lawyer? How did you get that? What was the key requirements?
I think for me, it's one thing, it's resilience. I knew where I wanted to be. I wanted to be a lawyer since I was 10 years old. I didn't
10 years old.
Sure how.
10 years old.
Yeah.
Wow.
Yes. So I wasn't sure how I would get there and where I would go. I knew I wanted to practice internationally. Again, I didn't know how I would get there. But I did take opportunities that came to me. I always had an open mind. I believe that I could practice anywhere. So even when I went to Saudi Arabia, when women weren't practicing there, I believe that I would find an opportunity to work, and I did find an opportunity to work. So I think you just need, it's about resilience, not accepting the status quo. When people tell you you will fail or tell you, oh, don't go there, don't do that. Think about, listen to your internal voice and just go for it.
Okay, thank you very much, Reshma. Big round of applause for Reshma, everyone. I'll move on to Mark. Mark, what's your advice? You're a role model to me. I look up to you. You're a FIDIC expert, and you've given so much, just like Reshma, Warda, and Suryan. What's your advice, and how did you get? What's your key attribute? What gets you going in the morning?
Thanks, Anil. I think that I've been on the adversarial side for so long, and I wanted to get a law degree in order to see how we can avoid these issues.
And Mark, sorry, at what age did you get your law degree?
I got it last year.
Wow. Wow.
At 51.
Wow. 51.
Yeah.
Wow. So this is huge. So please go ahead. Please proceed, Mark. Yeah.
So yes, and I believe there's always a better way to do things, and it's all about avoiding disputes, working together, growing the industry, because disputes actually, disputes in our industry is not beneficial for the industry. It breaks the industry down. If you're dispute driven, you're not going to grow the economy. There's a lot of youngsters that's coming to the industry that want to get into a dispute resolution. Focus should be on working to resolving disputes, avoiding disputes, and how to grow the economy, to grow the sector, to create a better world for everybody.
All right, Mark, thank you very much from South Africa. Reshma, thank you from Saudi Arabia, but mainly based in UAE. Warda, you're one of the rising stars in Mauritius. I look up to you, Warda. Why you are who you are today? What gets you going to give back in terms of the profession?
I think I've been lucky to have good mentors. So I've had the opportunity to have somebody take me under their wing. So that's why I think it's important to give back. And if I could help somebody else, that's something that I really appreciate.
Okay, and what's your advice to anybody looking to get into law?
Be patient. Be patient. It's not going to be easy. The world today, as in any technical field, is quite saturated. But if you love what you're doing, you will get to your destination.
You just need to get that passion.
Exactly.
Exactly. Suryan, I know you are a police officer, and today you are a senior associate in one of the leading law firms. It's a truly inspirational story from Suryan, the police officer from Mauritius, to in the UK. So Suryan, few words of wisdom and what gets you going in the drive.
Well, I'm going to just put what Warda just said, and even Reshma, you know, if you have a dream and you want to achieve something, and especially after you've shown that inspirational video, you know, you can achieve it. I mean, talking about background, I mean, after I left my A-levels after school, I didn't start my degree 7 years later, having worked, you know, as a police officer and as a banker for 7 years. But that said, in recent days, which is kind of heartbreaking, in the last few days, I saw the flood in Mauritius, which brought back memories. I mean, my background is it's not you know, the usual conventional public school educated person who's achieved and come to where I am now. You know, for those who remember, back in '79, I was a homeless kid. My parents lost their home in one of the cyclones with similar flood. That's why it brought my memory last night, looking at those videos on YouTube. Yeah, so from where we were, you dream and you're inspired, especially like what I said, if you have mentor, you build relationships, and I've been encouraged to go and study. And, you know, I left those careers and study. I've never looked back, and I've met great people. A lot of people have helped me along the way, colleagues, friends, former judges, and I just look forward, and that's where I am. And you could be doing anything. And one thing you mentioned about, you know, studying law, I mean, by studying law doesn't mean even if the market is saturated today. At the time I went to study law, people told me, you know, 21, 22 years ago that there were too many lawyers out there. But still, there's thousands of people who've qualified since. Everybody's working. There's demand for lawyers. Don't necessarily mean you will practice as a barrister, solicitor, in and out of courts, but there's a lot of things you can be doing. Like I'm doing today, you know, half of my work is doing mainly as an adjudicator, making, you know, decision on disputes. And then I'm also as a party representative. I would, you know, welcome any question if people want to contact me and ask me. But yes, you can achieve anything if you want to.
Okay, thank you, Suryan. Can we have a big round of applause for everyone, please? If you can put your little emoji on your phone. Kavira say thank you everyone for this amazing session. Ruan from South Africa say thanks to all the panelists. I'm sure I've been motivated. The final part. Adesi say million thanks to the organizer and the panelists. Insightful and educative session. It's a wonderful time listening and learning from you from Nigeria. We've got Vince from Conakry in West Africa. Thank you everyone for this amazing CPD talk, and look forward to a second session. Vince, you're going to pay for the second session on the common resolve cases on mediation. So finally, to conclude, Reshma talk about resilience. Mark talk about share the love, mediate. Warda talk about good mentors and passion. And Suryan say you could achieve anything. Guys, thank you very much indeed. Give you a big round of applause. It's 3 hours talk. It's truly incredible. It's never happened before. 3-hour talk on a webinar in Mauritius. It's never happened before. And I don't think it will happen again. Seriously. It's been a long, long webinar. And I would like to say thank you, everyone. So take care. Have a great evening. And don't forget to send me your feedback, your name for self-attendance, and we'll catch up later. So can I have a wave from all the speakers, please, for a final goodbye. And thank you, everyone. Take care. Bye.
All right.
Thank you. Thank you for watching.